Good morning and welcome to the D.C. Court of Appeals. I'm Chief Judge Blackburn Rigsby, and I'm joined this morning by Judge Howard, Associate Judge Howard, and Senior Judge Glickman. We have 3 cases set for argument this morning. Our first case is DIANDRE Caesar versus United States. Counsel, are you ready to proceed?
Good morning, Your Honors, and may it please the Court. Adrian Madsen on behalf of Appellant DIANDRE Caesar. I'd like to reserve 4 minutes for rebuttal. The evidence was insufficient to permit any reasonable jury to find beyond a reasonable doubt that, quote, the assailant acted in such a manner as would, under the circumstances, portend an immediate threat of danger to a person of reasonable sensibility.
Mr. Madsen, I have to stop you there. I have to say, you know, a part of the record was a number of the videos of this incident, which was quite bizarre in my view, that it escalated, at least from the video, to the point that brings us here. And so when you say that a reasonable jury couldn't find that Mr. Smith and his girlfriend were put in fear by Mr. Caesar, who comes from around the other side of a fence, banging on the car, appearing to and threatening that he would shoot them, even though they may not have seen the actual gun at the moment. They heard the bullet shots, gunshots, and there were bullet marks in their car. It just seems unfortunate and quite bizarre that incidents like this escalate to the point that it did here. Over a plastic milk crate, I feel like I missed something and had to play the video several times. So help me out here with this first argument. I didn't know that you would start right here.
Sure, Your Honor. Just to be clear, the government's theory here, at least as I understood it, as the government argued it below, was that the conduct in question, forgetting about whether we might consider surrounding circumstances in evaluating the later conduct, the conduct that the government alleged was the ADW was allegedly shooting this firearm, right? That's the conduct that the government alleges is the ADW here. That's what they argued to the jury below. So the ADW was not as charged as hitting the car, kicking the car, right? None of that is, again, we might consider that as background, right, as relevant to how they might perceive later events, but that was not the ADW that was charged.
It was very relevant, I think, to the circumstances there. So I guess
yes,
I'll let you explain why you think it was not.
Sure. So intent to frighten ADW, which is what the government proceeded on here, they expressly disavowed any attempted battery theory, requires both proof of intent to injure or to create apprehension, one of the 2 alternative theories, and then also requires this acting in such a manner as would portend an immediate threat of danger. And again, what the government is alleging the act here was allegedly shooting this firearm. And when we look at what the complainants observed with respect to that, with respect to a firearm allegedly being shot, they don't see a firearm, right? They don't see anything.
Stop you for 1 second. Don't we have to look at the intent of the defendant here, or the appellee, the actions of Mr. Caesar, as opposed to, you started out focusing on what the subjective perceptions of Mr. Smith and his girlfriend. But when we're looking at intent, don't we have to start with the inferences and facts that we can draw from Mr. Caesar's actions here?
Yes, Your Honor, but to be clear, I'm not challenging the intent, right? So the as would portend language relates to the actus reus, not to the intent. And what the the full quote there is, as would under the circumstances portend an immediate threat of danger to a person of reasonable sensibility. So there we are looking at, even though, as both sides agree, it's not the subjective perception of the complainants, right? It's an objective test based on what they perceived at the time, and so a person in their circumstances. And so, but to answer Your Honor's question, I guess more directly, in terms of evaluating intent, no, we don't look at Mr. Caesar there. We look at the complainants, right? And so which was where I was going with no, I don't mean that.
So you have Mr. Smith, his girlfriend, and their 2-year-old child in the car.
Correct.
And they have Mr. Caesar first shouting and running up to their car, coming out of the contained area where he was and meeting up with their car, claiming that he was going to shoot them.
Well, I mean, certainly I don't think there was any testimony that was that direct. That is, he has this bag that is on him, as they were mistaken about. He later had the bag on, as it was clear from earlier video footage and photographs that were admitted, he has this bag on him the whole time. I agree that he has his hand in the bag. It is a fact that is relevant, right? There's also testimony from the complainants that they don't believe that he has a gun at that time.
But there was
First
also,
she said, I think he's got a gun. That's what.
Well, I mean, of what she's depicted saying in Government's Exhibit 7 is, you don't have anything, it's not words to that effect.
She says both things. 'Cause
I agree.
She does say, I think he's got a gun. And then she says to Mr. Caesar, you don't really have a gun. But then they attempt to flee from him because they're unsure, perhaps, at best.
And again, part of this testimony that she thinks she has a gun is colored by the misperception, which she's confronted with at trial, that he didn't have this bag during the initial part of the argument, right? Ms. Bell or Ms. Green, or however we're referring to her here, testifies initially that no, he didn't have that bag, and I think he went and got this bag from somebody else, and that's what leads her, to this belief. When in reality, as the exhibits make clear, he has this bag the whole time. So in terms of evaluating, the reasonableness of that belief of whether or not there's a gun in this bag, I think that certainly has to play a role. So again, neither of the complainants see a gun. They don't see any object in the person they conclude is Mr. Caesar's hand.
but Mr. Manson, didn't they both testify at some point? I'm trying to find it in the record right now that they heard gunshots as they drove away.
So that is what they testified, as discussed a little bit in the brief. I think that's more of a lay opinion than the fact that underlies it, right? So going back to what Judge Blackburn-Rigsby was asking about, Chief Judge, Blackburn-Rigsby was asking about here, we're asking what a reasonable person in their circumstances would have perceived, right? So they hear loud noises, whether we want to characterize them as gunshots or something else, and at least Mr. Caesar's argument is that where they had not seen a firearm, where they had not seen anything in Mr. Caesar's hand, that these noises, right, that a reasonable person would not have interpreted those to be gunshots.
Do you really contend that there was insufficient evidence for a jury to find that Mr. Caesar fired a firearm at their car, at them, as they were driving away? It seemed to me that's the only question. If there was sufficient evidence, as I think there was, for a jury to find that Caesar fired at them as they drove away, then, ADW doesn't require any more. It doesn't matter whether they knew it. It doesn't matter whether they were afraid. It doesn't matter whether he hit them or missed them.
I agree. It does not matter whether it hit or missed them. I disagree, Your Honor, respectfully with what the actus reus that is required, as this court's case law has articulated it, that it does matter to some degree. I'm not saying it is.
It's a general intent crime.
I'm sorry?
It's a general intent crime, ADW.
So I know this court has.
You don't always talk in those general intent terms now, but
And so to be clear, right, I'm not challenging intent. I'm challenging the actus reus here, right? So when Your Honor says it's general.
so that's why right, I understand. If you think there was no shooting by if you think there was insufficient evidence to prove that Mr. Caesar fired a gun at the car as it was driving away, well, okay, that's material. I think there was sufficient evidence, but, I mean, you read that argument, I understand.
I don't think that's the inquiry, respectfully, Your Honor. That is, because part of the actus reus requires that the assailant acted in such a manner as would, under the circumstances, portend an immediate threat of danger to a person of reasonable sensibility. So built into there is an evaluation of the circumstances, how a reasonable person would feel in response to the circumstances as perceived by the complainants. And so I've talked a little bit in the briefing about how this court has never, at least in my review, done sort of this amalgamation that the government relies on here between the bus driver here, Mr. Graham, and the complainants. And so it's Mr. Caesar's position, I know Your Honor may disagree with it, but it's Mr. Caesar's position that hearing these loud noises, not seeing a firearm, not seeing a muzzle flash, that a reasonable person in those circumstances, that would not portend an immediate threat of danger.
So,
Again, I
Mr.
understand the court may disagree.
To press you a little further on my point, you don't think it's possible that there is any inference at all that could be drawn that a reasonable person, as the chief had mentioned, after being threatened with the possibility of a gun, even if they didn't see one, could interpret loud noises that, let's say they're not necessarily gunfire, but in the direction of it, as being gunfire?
So Your Honor, I think that, respectfully, I think the question is whether someone could conclude that beyond a reasonable doubt, right? I know we're on sufficiency review here, right? But still.
That's what I'm getting at with that
beyond a reasonable doubt, under those circumstances, no, is the argument. Unless the court has further questions about the sufficiency issue, I'd be happy to turn to the denial of the motion to compel. So
Could I just ask you a question? To follow up what you're saying, suppose the reasonable people in this case were fleeing in an armored vehicle and they had no fear whatsoever, and no one in that vehicle would have any fear whatsoever because bullets bounce off it. You're saying that wouldn't be an assault with a dangerous weapon?
Under this court's case law, at least as intent to frighten, it might be attempted battery, but I don't think it would be intent to
I mean,
frighten.
the intent, it could be the guy's just having fun shooting guns with no particular intent at all. I don't think intent matters. That's why I say it seems, I'm surprised that you think that it really matters whether a reasonable person would have been frightened.
I'm not sure. I mean, this court's case law says that it matters, Your Honor. I'm not exactly. I'm happy to turn to the specific quotes from the brief here, but this court's case law says that it does matter. I mean, take Parks, the case that is cited in the briefing. It's a little bit of an unusual circumstance where the victim of the ADW doesn't actually see what occurs, but this other single officer is what the observations are based upon there, and there this court says, well, subjectively, rejects the argument that subjectively the complainant has to experience fear, but again articulates this objective test, and it does matter that they do need to experience fear. Again, it might be other offenses, but it is not intent to frighten. Assault without a finding of objective reasonableness.
Well, even if that is true, you think a reasonable person in the position of people who are being shot at as they're fleeing a scene would not be in fear?
Well, again, based on the observations that they were aware of, no. They hadn't seen a gun.
But they don't have to be aware of it. We're talking about a reasonable person.
A reasonable person based on the subjective perceptions of the complainants. That's the way this court has applied intent to frighten ADW.
You're right. You're saying if you shoot at someone who doesn't know you're shooting at them, you're not committing an offense?
So in Parks, what this court said is that if there is a neutral observer, I mean, neutral it doesn't need to be, but a person who is not the victim, right? Another witness who is there, who in Parks this court relied on.
What if no one's there?
If no one is there, I'm not sure I follow Your Honor's hypothetical.
Well, you're talking about a neutral observer, if a neutral observer was there, but what if no one's watching?
If no one is watching and the complainants are not aware, that's not an intent to frighten ADW.
The question is not whether it's really, the question is really not whether it's intent to frighten ADW. The question is simply, the question is simply whether it's ADW.
And I'm sorry, are you saying that's the question because that's Your Honor's hypothetical, or is Your Honor saying that's the question because you think that's the dispositive of the sufficiency of the ADW here? Because the government expressly disavowed.
Personally, I think it's dispositive of the sufficiency of the offense, because ADW is not a specific intent crime.
Well, to be clear, Your Honor.
All you have to do is shoot at somebody, and you're committing an ADW.
The government disavowed attempted battery,
Without
right?
justification or excuse.
I'm sorry? I'm sorry.
You said the government disavows that. Well, I'll have to ask the government.
I mean, they did. That's the reason that the jury was instructed only on intent to frighten ADW expressly during the instructions. They disavowed that. I see that my time has expired. I'm happy to reserve the remainder for rebuttal, unless the court has other questions.
I was hoping that you would very briefly address the Winfield
Sure.
defense.
Yes, I'd be happy to, Your Honor. By way of background, there was a shooting in February of 2023, excuse me. There was a search warrant that was executed as a result of that shooting. The name of the person who resided in the apartment where that search warrant was executed was Zion Ray Valentine. When executing that search warrant, the officers recovered a gun that was linked by NIBIN, the National Information Ballistics Information Network, to the gun used in this case. The government disclosed some information, including that link, ostensibly pursuant to Brady, with respect to that search warrant. What the defense was seeking was both additional information that had been redacted from materials. So, we're talking about names that existed, but that had been redacted. Body-worn camera footage from the execution of the search warrant, and information about whether the suspect in this February shooting had been an informant. And the trial court, in denying the motion to compel, applied the ultimate, or appeared to apply the ultimate Winfield standard, rather than considering whether this was arguably material, right? And that was the error. And so we didn't even get to the stage of whether or not Mr. Caesar, might present a Winfield defense, because the trial court denied the motion and sort of cut that off at the knees. And so the government sort of, with all respect to Mr. Sable, sort of repeats the same error here. The cases that the government is relying on are about whether a trial court erred in precluding a Winfield defense, not about whether this was the information was arguably material. And as Mr. Caesar repeatedly reiterated below, that was all he was asking. He wasn't asking to present a Winfield defense at that time, but for this information that was arguably material under Vaughn and under Brady, in order to determine whether to seek to present such a defense.
All right.
Thank you.
And I guess, I'm sorry,
Yes.
before you sit down, just for completeness, there was one other argument in your brief about the sentencing, that the trial court erred
Yes.
by consecutively sentencing him as opposed to concurrently sentencing him.
Yes, and to be clear, the argument is not that a trial court could not permissibly sentence them consecutively. That is, the trial court appeared to believe that
That she did not have discretion, is that what you're saying?
either that she did not have discretion, or that either the ADW statute 22402 or the possession of a firearm contains some presumption neither of them did that legal error. She says, and so I am going to sentence them consecutively. Certainly she never relied on 23-112, which the government cites to here. That she doesn't say sort of, offenses are presumed to run consecutively. She seems to be honing in particular on these statutes, and that's just an error of law that impacted the sentencing. And so even if the court does not vacate or reverse the convictions, resentencing is required.
All right, thank you. All right, Mr. Sabo?
Thank you, Your Honor.
Right.
May it please the Court, David Sable on behalf of the United States. On the sufficiency, I'll just say very briefly, in addition to all the other evidence that we've talked about, there was the bus driver who saw the
Mr.
slim.
Sabo, could I ask if, I don't know if the podium comes up any higher, but it's a little hard to hear you.
It's here on this side.
Isn't this it? Tell you that you're supposed to practice with these things before you get up to the, that's like in every moot court class, they tell you that. In addition to all the evidence, is that okay, Your Honor?
Yes.
In addition to all the evidence that we've discussed about the sufficiency, there was the bus driver who observed a slim black male about 6 feet tall firing a gun into the rear of the white car as it drove away. And again, as Judge Glickman, I think, was suggesting or asking, firing 4 bullets into the rear of a car is an ADW, and there's abundant evidence of that.
Well, if there are people in it, I guess.
Well, yes, right. Thank you, of course. And of course, probably the confusion that the jury had, if you look at the notes, was that they just didn't know if Mr. Caesar knew that there was a kid in the back seat. So that's why they acquitted on the kid. But they convicted on, there was an infant in the back seat. They convicted on Ms. Green and Mr. Smith. Turning to the discovery issue, Your Honor, what the government said was,
Well, I guess before you turn to that issue, can you address the argument more directly that appellant's counsel made about the mens rea element?
well, the government
distinction-
proceeded
yeah.
on an intent to frighten theory. We cited the Powell case. You have to prove an intent to frighten, and a reasonable person can infer an intent to frighten if I'm firing a gun at a car with people in it, that I'm intending to frighten them, whether or not they are subjectively frightened or not. And I disagree with Mr. Madsen that I can only be confined to the evidence that would come from the victims in this case. We had eyewitnesses, we have video, and of course, as Judge Howard pointed out, the victims testified. I heard the gunshot strike the car, and as you pointed out, Your Honor, as you watch the dash cam video, you can hear the bullets hit the car. So that alone, of course, you have the bullets recovered from the back of the car and the shell casings from the scene, permits an inference that they were being fired at. So any way that you slice the elements here, the evidence is overwhelming. I don't know if I've exactly answered your question, Your Honor, but I think the evidence is overwhelming of intent to frighten. And Mr. Madsen's talking about the Powell case that talks about
Parks?
but we think the evidence is overwhelming any way that the court approaches this. If I can just turn to the discovery issue. So in June of '22, Caesar shoots at the car with this 9mm, and the casings are found on the scene. 9 months later, the police execute a search warrant in March of '23, and they recover a gun in the home of Zion Ray Valentine that produces a Nibin hit to Caesar's gun. We disclose that. We disclose all the information from the search warrant except for the video. Zion Ray Valentine does not look at all like, he's a big, heavy-set guy. He's not a Winfield defendant, even according to trial counsel, defense counsel. But the reason the police went in there was because in February, so 8 months after the shooting, there's a shooting, Valentine is the suspect, and there's a casing found on the scene. That casing, it goes to Nibin, and it is not a match to our shooting. So the February shooting is connected to this apartment, but it's not in any way connected to our shooting. And what Judge Hertzfeld said was, okay, the search warrant, all that has to go over except for the video, which nobody thinks the video has anything that they don't already
What was
have.
the video, again, that you're referring to, was a video of what, the shooting that?
No,
Mr.
of the execution of the warrant. I guess it would be body worn. The officer's body worn as they walk around, but all the paperwork, all the evidence was disclosed from the search warrant. The shooting itself, Valentine was the suspect, but the prosecutor told the judge, Judge Hertzfeld, we recovered a casing, and that casing is not a match. So, and Hertzfeld said, well, as a result of that, it's too speculative. And so again, Rule 16 says we have to turn over anything we have that's material to the defense. Well, so if you're saying that your defense is Winfield, is it material to a Winfield defense? And I think the language this court has used is reasonable indication. So do you have a reasonable indication of a Winfield defense or reasonable indication of Brady? And again, we don't have that here.
Well, but why don't they have at least an inference under Brady that this evidence might be material?
It's pure speculation, Your Honor. At least that's what Judge Hertzfeld said, and I think that that is correct. I mean, what is your argument that, the argument that was made below was, oh, we think the February shooting could be connected to this shooting because you went into that apartment only because of the February shooting. Okay, but the gun used in the February shooting is not the gun used here. So what's the connection? Oh, well, maybe we think they both involve small sales of marijuana. And the judge said, well, that just isn't going to fly. That's just too common. So there really isn't a connection.
Well, but the Brady standard is materiality. It doesn't have to be connected to their third-party defense that they might have made or were trying to make, does it? Isn't that's an earlier step in this determination where?
Sure. I think something could be exculpatory on many different theories, not just a Winfield third-party perpetrator theory. But so what is your theory? And this question was asked. They have no theory. There's no theory of materiality. This is just another shooting in the District of Columbia that is not in any way linked to our charged shooting. The government had no obligation, and of course, this is a pending investigation. They wanted witnesses.
Except by the gun that was used in Mr. Caesar's case, right?
No, exactly no. Because the February gun is not the June gun.
No, but the gun recovered in Mr. Valentine's apartment is the June gun, correct?
Probably, right, probably.
That's how he got the hit in the whatever system, Niles, I'm sorry.
Niven.
Niven.
Right. And so, but that gun is not the February gun. So what's the connection between the March gun and the February gun?
I get that we're
Especially
dealing
if you know,
with,
I'm sorry.
I get that we're dealing with degrees of attenuation, but wouldn't you say that at least somewhere along the line of reasonable to all the way out in left field but possible was the idea that they're tracking, okay, well, this gun doesn't seem to be in Mr. Caesar's possession. Perhaps it never really was in the first place. There was a third man on the grassy knoll, and so we need to talk to those witnesses to try to see if we can figure out where this gun came from, where it's gone, what the chain of custody and possession's been.
Well, you also have the idea that you've got a big, heavy guy that nobody thinks is DIANDRE Caesar doing the shooting in February. So how are we even connected to that shooting? In
I'm
what
not
way?
saying that it's not extremely attenuated, and I'm not even saying it's a winning argument. I'm just saying, not saying that our big, heavy guy was the actual shooter, but we've got a gun that's no longer in Mr. Caesar's possession that pops up here in a seemingly unrelated place. Is there some conceivable universe, and I'm not saying that's a winning argument, but is there some conceivable universe where we track custody of this gun and Mr. Caesar is able to make his Winfield defense, a hypothetical one of somebody else had this gun, not me, so it couldn't have been me?
The burden would be on the defendant to come up with at least a theory, an articulable theory, a reasonable indication is what this court has said. So they have to come up with a theory.
But the reasonable indication is the Winfield theory, not the Brady materiality.
Right, so the exculpatory theory that they propounded was that would be Winfield. Except the problem that they had with that, in addition to the fact that this isn't the same gun. And let's assume that Zion Ray Valentine had an arsenal in his apartment, right? He had the gun that was used in June, and then he had another gun that he used for February. Okay, maybe. But then he's not the guy. So now how does your Winfield theory go? I mean, who has this other gun? Somebody who doesn't look like a Zion Ray Valentine. It's tough. And then now you're speculating about a different person with a different gun, and so all you have is the fact that the police executed a search warrant a month later.
Do I understand that Mr. Valentine told the police that he had found the gun in a trash
Yes.
bin of some kind?
Right, and he pointed,
So there's no real prospect here, if I understand correctly, of going back and tracing the ownership or possession, tracing the possession of the gun to somebody other than appellant here.
right. I mean, we also know, because we're not naive, and we've been doing this for a while, that guns move around a lot, especially once the gun gets a body on it, he's a shooting, they get traded, they get sold. Over 8 months, that could have gone through countless hands. And so, yes, potentially, a knife and hit, particularly if it's close in time, can be probative, and we consider that to be Brady exculpatory information. But there is a matter of degree, as Judge Howard said, and here we're well beyond it. And I think it's difficult to say that Judge Hertzfeld, when she said too speculative, too attenuated, that she erred or abused her discretion.
Do you have another case you could point us to where we see this same interplay between Brady and what's material and potentially exculpatory, and then Winfield? I guess I've not seen a lot of cases where these two theories are sort of conflated in this way.
I think we relied on the Bellinger case, Your Honor, which is an old case. It was a Brady case where there was a knife and hit much closer in time and closer in location, and it's been up before the court a couple different times. And the government did not turn, it was retroactive, the government did not turn over the information, so the question was whether it was exculpatory. That might be of some help.
Okay.
I would just finally say, Your Honor, in terms of harmlessness, if I could just point out, we think that the evidence here was overwhelming, whether you're talking about the ID or sufficiency, because not only do you have the identification from Mr. Smith, you have his own colleagues at work saying that he's on the scene and putting him on the scene, and one of whom, Mr. Pete, says, yes, I dropped him off to cut the grass. He was the only one there that day. I came back, and then he was running past me. He's the guy in the
pickup truck.
Thank you. And then he hops the fence, and then yes, he was involved in an altercation with a white car. He doesn't want to give up the gunshots, but we know about the gunshots. The bus driver, the officer who's there, and then ultimately you have the video. And I would submit, as Judge Leibowitz and Judge Hertzfeld both said, not findings, but they said it was pretty darn clear that that was Mr. Caesar in the video.
Any further argument on the issue of the the consecutive sentencing?
Thank you, Your Honor.
And whether or not there was a failure on the part of the judge to recognize discretion that she may have had to sentence concurrently?
Very much disagree with Mr. Madsen's characterization of what the trial court said. This is what she said. And I think the statutory scheme contemplates that should be consecutive to the possession of a firearm during a crime of violence. So the sentences on each count will run consecutively. So I read that as her saying, I can impose a legal sentence consecutively or concurrently. I have discretion. I'm choosing discretion. The statutory scheme gives me a nudge towards saying, I think the statutory scheme is thinking about it consecutively, but I don't even view it as a presumption. So she recognized her discretion and purported to exercise it. But on top of that, I would say she's not wrong. She's not wrong. I mean, I know the Superior Court sentencing guidelines will say you can run them concurrent or you can run them consecutively. But this court has said in Herring, district law presumes that sentences run consecutively unless the court expressly indicates otherwise, citing DC Code 23-112. So if a judge doesn't say consecutive or concurrent, it's read to be consecutive. And that's not just a way of reading the J&C, that's also a way of saying what the court has said in the double jeopardy context. You know, so we have the Freeman case and the Herring case. ADW and PFCV don't merge under Blockberger, right? Because they both have elements that the other one does not. But more than that, they both address different societal interests. I mean, you might look at them and think it's kind of the same thing, but this court has said no, and the council said no, they're different societal interests, which led the court to say in Freeman that the council contemplated that multiple punishments would be imposed for ADW and PFCV. That's what this court said in Freeman, contemplating multiple punishments. Now, multiple punishments in the double jeopardy context are not the same as running things consecutively, because we know that multiple punishments can also be concurrent sentences. But it's clear that if Judge Hertzfeld is saying, hey, I think the statutory scheme contemplates, which I take to mean thinks about, suggests consecutive sentences, if that's her view, I don't think she's wrong. If there are no further questions, I ask the court to affirm the judgment of the Superior Court. Thank you very much.
All right, thank you. Mr. Mattson?
Thank you, Aaron. And just to be clear, sort of not to belabor the point, but where we started and where the government started here, again, Mr. Caesar is not challenging the sufficiency of the intent here. Again, he's challenging the actus reus, which has this other component. So just there was some discussion, again, about intent, and that's really not what's at issue in this case. With
Is
respect
it appropriate to take your argument to say that we should just limit absolutely everything to the individual victims and their perception of things, and it's essentially if a tree falls in the forest and there's no one there to hear it, does it make a sound?
Not precisely, Your Honor. I mean, Park says that if there is this other single observer who views all of the relevant acts, the court can say, take from that from those observations that and objectively that a reasonable person would fear harm in those circumstances. What this court has not done, however, is to sort of rely on an amalgamation of this observation from this observation from this person in terms of establishing that fear.
So why wouldn't the bus driver be enough?
So the bus driver, what his testimony is, that he says that he hears, in his words, pop, 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 and then he sees a car start driving, right? And we know from Government Exhibit 7 that he's wrong about that, right? That is that there's no noises that happen there, and because the car is heading west on New York Avenue and the bus driver is heading east on New York Avenue, even if, as we do on sufficiency review, we assume that he saw, the bus driver, that is Mr. Graham, saw the person the jury concluded was Mr. Caesar with a firearm, he wouldn't have seen, based on the angle, what he was firing at. And that's what I mean when I say I am not aware of any case in which this court has sort of said, well, we're going to take this observation from this person, we're going to take this other observation in order to...
If we limit it back into the victims in the case, they drove away fast, we have that clearly on the record, and they went to a gas station and they got out to check the car. How does that not demonstrate some apprehension or fear if something has happened to my car?
So again, it's not subjectively whether they experience fear, right? It is that take the facts that were apparent to them. That's what the under the circumstances language is that is in Powell, that is in Parks, and so what we have are they have this heated argument. There's a person standing there, they begin driving away, and they hear these noises, right? Taken down to their bare facts, they don't see a gun, they don't claim to see him pointing in their direction, right? They don't say there's some other object. And so the question is, how would a reasonable person with those observations, would it portend beyond a reasonable doubt an immediate threat of harm?
I don't see how that doesn't play in at all, though, then. You're saying it's just purely subjective that they decided to pull over, that they needed to look at the car. That doesn't add anything to the objective analysis at all?
I don't for lack of concurrence, Your Honor. That is, take for example, there was also some discussion about, finding the bullets later, right? That is, the question is the circumstances as they appeared to them at the time of the actus reus, right? We need concurrence. And so the circumstances of both leading up to that, right, and at that time wouldn't include, the later experience of fear by virtue of the fact of finding the bullets, right? There's no concurrence there.
But don't they see Mr. Caesar at the moment he comes up to the car window with his arm cocked in a position that suggests that he might have a weapon, and he is threatening them at that time?
So they do see Mr. Caesar when he comes to the window. Again, that's not the charged ADW. I agree that it is a fact that can be relevant to considering whether a reasonable person would later experience fear based on the totality of the circumstances, but it's not itself the charged ADW. I don't think, in terms of, Your Honor used the language threats, I mean, and I know Your Honor means that colloquially, there was no, charged threat here. There definitely were heated words exchanged, I agree, sort of from both sides, and an escalation that I agree made no sense. But I don't think it was as clear as, I'm going to shoot you, right, in terms of the evidence that was there. And again, both Mr. Smith and Ms. Bell were mistaken regarding whether this bag was on him the whole time or not, which certainly colored their perception. I see that my time has expired. Just briefly.
Is it your position that if Mr. Caesar fired shots at them, but they didn't know it, he hasn't committed an assault?
If there is, again, that's sort of maybe is the answer, depending on parts, right? If there is a person, right, who sees the entirety of that,
nobody sees it.
then that is not an intent to frighten ADW.
See, I don't think that's the right way to think of intent to frighten. I'm getting a better sense of what your position is. I think we ask ourselves, did an assault occur? Well, assaults often occur when there's an actual physical contact and what have you. But another way an assault can occur is if a person, call that person the victim. If that person were aware of what was happening, that person would be frightened. That's the difference between shooting a paper plane at somebody, a paper airplane at somebody, and shooting a gun at the person. But it doesn't turn on whether the person, I don't think it turns on whether the person is actually, whether there's an assault. It turns on the question whether the victim is actually aware of the gun being fired at the victim. It's still an assault.
Somebody needs to be aware under intent to frighten assault. That's what I'm saying. In parts,
presumably the shooter has to intend his act.
Again, with respect, Your Honor, that's conflating the intent and the actus reus. That is I mean,
it has to be a deliberate act. If it's an accident, it's not an assault.
Sure, I would agree with that. But what I mean to say is, I mean, that's parts, right? Take Your Honor's hypothetical. If there's a person there who sees it, who is not the complainant, I agree that can be sufficient to establish intent to frighten.
But you think if nobody sees it?
If nobody sees it.
It's like a mystery novel with the perfect crime. If nobody sees it, you think it's not an assault?
Well, I guess as a practical matter,
Nobody
the
sees
government
it,
wouldn't be able to
and
prove
if-
it out.
And
But
if the shot misses, so the victim doesn't suffer any actual injury.
we,
I think that's not an assault?
it may be an academic question because there wouldn't be anyone to prove it up if no one sees it, how it's going to be established.
It might have been caught on a
But
photograph and then, later, or the shooter may admit it later on.
I think that, no, I don't think it is under this case law. Again, it has to be, a reasonable person based on again, either the subjective perceptions of and when I say subjective perceptions, I mean the facts, the observations that they have. Or, again, in the case of Parks, we have this other person who we're saying is standing in the shoes, essentially, of the victim, that they would have been afraid. But if there's no one satisfying either of those, then no, it's not. It might be another crime. Again, it might be attempted battery assault, a theory of ADW, but it's not intent to frighten ADW.
So the argument is Berkeley, the objects of sense only exist when they are perceived.
That's fair, yes. And again, I realize my time has expired, but just I want to reiterate regarding the Brady issue, Chief Judge Blackmun-Rigsby, I agree exactly with one small distinction. It's not just materiality. Because we're at the pre-trial stage, it's arguably material, right? And the error here that Judge Hertzfeld made was employing sort of entirely the wrong legal standard. In terms of evaluating the harm from that, it's very difficult, to be frank, to evaluate the harm because to go back and say what would the investigation have been, and so it is difficult to establish that harm. Unless there are further questions, I would ask that Mr. Caesar's convictions be vacated, reversed, or in the alternative that the court remand for resentencing on this issue.
Thank you. All right, we thank both parties for your briefs and arguments today, and the matter will be submitted. Thank you. Our second case this morning is Michael Chase v. DC Metropolitan Police Department. All right, good morning. Counsel, are you ready to proceed? Okay.
Good morning, Your Honors. Tamara Jones on behalf of Appellant Michael Chase.
Good morning.
May it please the Court. This case is about an error of law before this Court on whether or not the District of Columbia may deny a law-abiding federal firearms license dealer the right to carry a handgun for self-defense when engaging in his lawful business, despite the fact that his civil and firearm rights have been restored in the original convicting jurisdiction, which also nullified his conviction.
So how do you distinguish that from Porter, our recent case that came out and was addressed at least by the government in its briefing? In that case, you had an actual expungement that under Maryland law purported to make the conviction as though it never existed, and yet this court determined, and we're bound unless we're the en banc court, to go along with that, that was not enough. The conviction still stood for consideration under this regulatory scheme. Here the conviction still exists, right? The rights have been restored, and your argument is really that it's a conviction, but not really because it has no effect anymore.
Yes, Your Honor. I believe that case is distinguished in this case because the regulation explicitly states that a set-aside or pardon should not be considered when applying, when granting a license. And in that case, the regulation didn't explicitly mention expungement, and so I think it can be differentiated in that way.
Help me understand that a little more. Like that seems like a distinction without a difference. An expungement is something greater than a pardon. It at least as the Maryland law defines it, eviscerates a conviction. And in the restoration of civil rights doesn't eliminate the conviction itself. A pardon, as the government points out in its briefing, does not eliminate the conviction itself, and those are still considered for various purposes. Why is that what feels like a more extreme situation in Porter in a favorable sense towards your argument, or a favorable sense towards the general argument? Why is that distinction? Why is that a distinction? Sorry, I'm just struggling to comprehend it.
I think, Your Honor, in this case, the distinction would be based on the facts. In this case, the appellant is also a federal firearms dealer, and not only that, he has an exception under DC Code 224505, in which it states that a person who's engaged in the business of manufacturing, repairing, or dealing in firearms can possess and carry a pistol in the ordinary course of business. And in this case,
Self-defense, the ordinary course of business?
not in this case, Your Honor, yet there's a nuance in this matter, because not to say that because he's issued a federal firearm license that DC should honor that issuance by the federal government, but it shows that he isn't a prohibited person, because part of that requirement is that a felony cannot be issued a firearm carry license. Also, in the ordinary course of business, in this case, in dealing with firearms, it can be understood that a person coming into the district carrying a numerous amount of firearms would be required to be able to defend themselves in that circumstance. And so, although self-defense isn't explicitly a part of this ordinary course of business, it is implicit in a firearms dealer who comes into the district with several firearms, especially considering the crime in the District of Columbia. Okay, so the errors that we are asking for reversal on are also in which the OAH erroneously concluded that the full faith and credit does not apply to the District of Columbia, as well as the OAH misapplied the DC Municipal Regulation 242307.3 by failing to recognize the restoration of Mr. Chase's rights in Virginia, which constitutes a set-aside conviction, specifically the definition of annulment, which is operative term in the regulation. And in this case, the Virginia court's final order annulled Mr. Chase's conviction.
Is your argument that it annuls it specifically to gun possession rights, or that it annuls the conviction broadly?
It's our position that the final order in Virginia annulled his conviction to qualify him under the regulation, because the regulation explicitly says set aside, and the definition of the set aside encompasses annulment. And so in that case,
what I'm asking is, are you saying that his conviction is truly annulled? It has no further collateral consequences for him anymore? Or is your argument narrower, just that we should consider it annulled solely for purposes of gun possession in this context, because that right was given back by the court by a court order?
Our position is both, Your Honor, that the legal consequences of his conviction have been terminated, as well as the final order of the Virginia court annulled his conviction as well.
The government argues that not all the legal consequences of his conviction in Virginia have been terminated. It suggests, for example, that if he were on trial, he could be impeached with that conviction. How do you respond to that?
Your Honor, our focus is that the appellant qualifies under the regulation. So that's our main position, is that the government should acknowledge that according to the terms of the regulation, he qualifies under that for a firearm
You mean
license.
because you say that certain of the consequences of his conviction have been set aside. The government draws a distinction between setting aside the conviction and setting aside the consequences of the conviction. You don't think there's a distinction there?
I do, Your Honor. I do think there's a distinction, and that the law does state that a person's conviction who has been set aside can come up in court. But in this case, it doesn't apply for the requirements under the regulation in order to issue a firearm license.
Do you think that the government's action in this case of denying Mr. Chase the license he requests, the concealed carry license he requests, because of his, I guess by now, over 10 years old, conviction of a felony, do you think that raises any Second Amendment issues?
Yes, Your Honor. In this case, when it comes down to Mr. Chase being a part of the exception where he can carry in the ordinary course of business, the OAH did concede that he falls under that exception and that he can possess a firearm in the district. It was in their opinion that although he could possess a firearm, he cannot possess a loaded firearm. So it's our position that in some effectively, they are using the proper purpose, which Bruin determined was unconstitutional, because they're saying that Mr. Chase can carry for this proper purpose of handling his firearm business, but he cannot carry a loaded firearm. And so also, the government...
The ability to protect oneself from an attack with an unloaded firearm is somewhat impaired.
Yes, Your Honor, as well as the government cannot meet its burden to show that there's a historical tradition that supports the regulation to exclude people who have their firearm rights restored.
So, sorry to keep hammering at you there. What I'd love for you to address on that point, because I'm a bit confused by it, I get that Bruin came about, but in Heller, the Supreme Court, and not saying I necessarily agree or disagree with anything, but the Supreme Court said that bans on former felons possessing firearms was presumptively valid. We then went forward, and before Bruin happened, the D.C. Circuit, looking at the federal law, which is virtually identical to our law, goes through a historical analysis in Medina in 2019, and goes all the way back and points out not just the felon, not just individuals involved with gun charges, but that theft and certain other charges were considered capital offenses at the time of the founding, and did this historic analysis that Bruin then looks at and it marks off its approval of. And then we have a 2025 case, Johnson from the D.C. Circuit, which notes again that same approval in Bruin, and then lack of effect of Rahimi. It looks like the history has been fairly well established in case law. How do you distinguish those cases and the history from the Second Amendment enactment period, the 1790s that they've got there?
Your Honor, if your specific question is asking about the prohibition against felons, which I believe that's what you're asking, we agree that felons are prohibited, but in this case, those cases didn't speak to fully restored citizens who have nonviolent crimes that have been annulled by the convicting jurisdiction. And in this case, the government acknowledges the Virginia court's conviction, Mr. Chase's conviction, but they don't acknowledge in the same sense when that court nullifies the conviction.
But if you're acknowledging that, then doesn't that shift the burden? That Bruin step one is already done. The government has its historical precedent, and now the burden is on you to draw the distinction, which you are doing here in pointing out the difference. But it's not really the government's burden to establish the historical antecedent at that point, is it?
I believe that, well, according to Bruin, the text and history standard requires the government to meet its burden to show that the regulation is supported by tradition. And I think, again, it's the fact that the government can't meet its burden to show that the history or the regulation supports justifying prohibiting a person who's been fully rehabilitated, as well as that has a nonviolent crime and has been presumed to not be prohibited by other jurisdictions, even the federal government. I don't believe that the government has met their burden to show that a person in that situation is prohibited.
How do you explain the tension between two statutes at issue here? There's 7-250203, A2, and 24, well, a statute and a regulation, rather, and then 24 DCMR, Section 2307. Wouldn't the statute normally trump the regulation?
Yes, Your Honor, it would, yet in this case, the statute does not include any exceptions, and the municipal regulation does include the exception, which Mr. Chase falls under, as well as there's a statute, 224505, which is an exception which Mr. Chase falls under. And so I think that they pretty much flow together well to support each other, where one does not have to trump the other. So, in further, I think it's important that, an important nuance in this case is that the OAH did concede that Mr. Chase falls under that exception. The issue is that whether or not he can use the firearm for self-defense, and it is our position that he can, and it falls down to the word set aside. The government argues that a set aside doesn't vacate a conviction, yet they also included a word, the agency included a word in their definition of set aside that was not in the regulation, which was innocence. And if the legislator intended for the regulation to include innocence, then they wouldn't have included the word pardon, which doesn't require vacator. And so in that sense, reading the regulation in the plain text, it shows that the legislation meant for a set-aside or person whose charge has been nullified, as in Mr. Chase, to be included in the exception. And that is our position. And so we're asking the court to look at the plain text of the regulation and honor, and ask for MPD and the agency to honor the terms of the regulation.
Counsel, I think if we were starting with a clean slate and didn't have the Porter decision of this case to contend with, your argument makes a lot of sense, that we have the set-aside language in the statute, we have the conviction set aside, so to speak, in both Maryland and Virginia. I think that argument makes sense, but I can't seem to reconcile it with what our court said in Porter, where you had a clear expungement, which seems like it's further along on the spectrum of clear, let's wipe this out, expunge it completely. And this court found that that still didn't alter the provisions of our statute and the purpose of our statute and regs. I'm not sure I would have, I think writing on a clean slate, I would tend to agree that someone shouldn't be banned forever when they're nonviolent criminal convictions have been set aside. But I feel like we're a little stuck here with the precedent that we have.
Your Honor, well, if the court looks to the difference of the fact that the Virginia court restored his rights, which was a final order, then the court could look to the faith and full credit in the fact that his rights were restored and not just that his conviction was annulled.
But the full faith and credit analysis still requires us to take another step and look at whether our interest in the District of Columbia of prohibiting convicted felons from possessing weapons, if that is the interest that the statute is trying to protect, whether that's greater than any interest that Virginia has. Don't we have to take the analysis a step further? We don't normally just rubber stamp. In other words, giving full faith and credit doesn't mean it's a blanket rubber stamp of whatever has happened. It means we consider it, we weigh it, we apply it where reasonable as applicable in our jurisdiction.
Yes, Your Honor. I do believe, well, the discretion, rather than it being a full blanket, comes with the Metropolitan Police Department, because following the regulation is just the initial step. And so if the MPD and the agency is required to follow the regulation as the council intended, they still have discretion after that in order to determine who could be issued a license. And so in this case, we're just asking that the government be required to follow the regulation as it is written, rather than it be a blanket opening for anyone to encompass a firearm license.
But if it's discretionary on the part of the agency, MPD here, under what provisions or basis would this court make it mandatory to require them to do it?
Your Honor, because it's discretionary after the regulation is followed. The regulation is the first step, and then once they follow the regulation as the council intended, then they have the discretion to determine who they issue a license to. But the first step is following the regulation as it was written and intended by the council.
That feels like a step beyond where some of the discretion is. That seems premised on that that the city must give full faith and credit to your interpretation of what Virginia is doing. Like, full faith and credit, all parties agree, applies to the District of Columbia just as it would any other state. But District of Columbia, like any other sovereign, has a police power to protect public health and safety, and so it has a right to put in its own regulations. And so you're asking us, and I'm not necessarily saying it's reasonable or unreasonable, to interpret something short of what we saw in Porter as being effectively setting aside a conviction. And I'm not sure that's there, especially if we look at some of your original argument at OAH, where you cite to the federal statute, and that includes language that mentions setting aside and having civil rights restored, et cetera, showing that these are two separate things as a legal matter in at least that context. I've compounded two different concepts for you.
Yes, Your Honor. So essentially, we're not asking the court to change the discretion of MPD. We're asking the court to require MPD and the agency to follow the regulation as the council intended. And it boils down to the word set aside, which includes annul, which the Virginia.
Keep saying as the council intended. Did the council pass the regulation?
The regulation was passed by the council, Your Honor.
Okay.
And so that's what we're asking, is that the court require MPD and the OAH to follow the regulation as it is written. And so if they do that, then it includes set aside and annul, and Mr. Chase's conviction has effectively been set aside and annulled. And so if they follow that, then Mr. Chase would then be able, not necessarily to be granted a firearm, but at least he would meet the threshold requirement, which is what the law says. So once he meets the threshold requirement, then MPD has the discretion to decide whether or not to issue him a firearm license. But in this case, MPD and the OAH did not follow the regulation because they included terms that were not in the regulation, such as innocence.
Well, Ms. Jones, I know you reserved some time for a rebuttal.
Yes.
Is there anything further?
No further.
Okay.
Thank you, Your Honors.
Thank you.
Thank you, Your Honor. May it please the Court, Marcella Coburn for Respondent, MPD. You should affirm because Michael Chase has been convicted of a felony, and people who've been convicted of a felony are not eligible for concealed carry licenses in the district. The only way around that
Does that
under...
seem extreme?
Uh,
That here, the felony that Mr. Chase was convicted of is nonviolent, was a nonviolent felony. His business and livelihood is selling guns and weapons. Maryland and Virginia, our neighboring jurisdictions, have recognized that. It just seems out of step with Heller and where the Second Amendment jurisprudence is headed generally since Heller with respect to the ability of people to carry guns in the District of Columbia for self-defense in their home. And then, this reason sounds compelling. It's not a general carry around, walkabout with a gun. It's a part of a person's livelihood.
I don't think it is extreme, Your Honor, and I don't think it's out of step with Second Amendment jurisprudence. First of all, I think the court is right to be looking at Porter, which I think addressed a lot of the issues in this case. One of the points that Porter made in looking at the legislative history of the felony disqualifier statute was to say that the council intended to protect public safety by keeping firearms out of the hands of people convicted of felonies. And it looked specifically at how best to keep lethal weapons out of the hands of people that it thought wouldn't be law-abiding or could be dangerous.
So what was Mr. Chase's felony again? Underlined?
His felony here was a grand larceny in Virginia.
So how does keeping him from carrying a gun after he's been cleared of both of these, in both other jurisdictions for larceny, protect public safety in D.C.?
A couple answers to that, Your Honor, but the first thing that I want to clarify is that his conviction has not been annulled. His conviction still exists. Virginia has chosen to remove some of the consequences of that conviction, and that's a policy decision that Virginia and many other states are free to take. But the conviction itself still exists. I don't think there can be any dispute about that. But I think what the court said in Rahimi and Bruin and Heller is that for long-standing historical reasons, prohibitions against felons possessing firearms are presumptively lawful. And I think every appellate court who has looked at the question of the facial constitutionality under the Second Amendment of that prohibition have said, we are confident that this provision is facially unconstitutional. I think what the court is getting at is a more specific as-applied question about the constitutionality under the Second Amendment as applied to Mr. Chase. But in this case, I think that question has been completely forfeited. It has not been raised by Mr. Chase in this case, because the argument that Mr. Chase has made in his briefs is purely one of facial constitutionality. And if the court wants to see what I think is the best distillation of that, it should look at pages 13 to 14 of his opening brief. And what he says there, and this is how he describes his Second Amendment challenge: by parsing out the appellant because he has a conviction for a crime punishable by greater than 1 year in prison, the appellee has carved out a substantial part of the American population and prevented them from defending themselves with arms as guaranteed by the United States Constitution. That's not referring to his crime of conviction as grand larceny. It's not even referring to dangerousness or even being law-abiding. He is purely raising a facial challenge.
Can I ask you to indulge us
Sure.
for a moment? And would you just let me know what your thinking would be if this were an as-applied challenge.
Sure, I can tell you how some other courts have addressed these kinds of questions. First of all, in some of the cases that we cite in our brief in the Fourth Circuit and the Eighth Circuit, many of those circuits have said you can't really raise a felony by felony as-applied challenge under 922G1. The answer there is it is still a felony, and therefore the government has the authority to restrict you from possessing a firearm regardless of the nature of your conviction. And so I think the court could look to the Hunt decision in the Fourth Circuit to explain the logic of that decision. I think the Medina decision in the DC Circuit also has that same logic, and specifically also says, you know, if you're as long as you're not a law-abiding person at all, regardless of the dangerousness or violent nature of your underlying felony, it makes no difference. The state has the authority to say, we don't want you to possess firearms. Again, that's a policy consideration. Other states can make different determinations, but that is allowed.
Suppose, let's just take a hypothetical. I'm wondering if this really stretches all the way to, you know, the graveyard. Suppose a person with an otherwise unblemished record at the age of 20 commits a nonviolent, comparatively not that serious felony, first-degree theft of some kind, say. And perhaps the person is even given probation, but the person serves their sentence. At 23 years old, the person is, let's say the person is no longer under probation or parole, and goes on for the next 35 years to live a completely blameless life. Maybe an exemplary life. No prior convictions. The felony is still on his record, on their record. Do you think that the Second Amendment tolerates saying to that person, even after all that, your constitutional right to be able to defend yourself is going to be curtailed?
I do, and I think many circuits I've mentioned have agreed with that perspective. And I think the reason is that Bruin has now directed us to make a historical analysis. And under the historical analysis, the state's authority comes from its ability to categorize people as dangerous or not law-abiding. And in that way, when the legislature is able to do that, it does have the power to disarm those individuals. And in fact, we cite in our brief, you know, there are situations where a felony is punishable by death. And courts have said at that point something.
I was going to come to that. Historically, many crimes were punishable by death, or worse. But we don't follow that now. We don't say, you know, I mean, we'd be horrified, and I can't believe we would say that nonviolent theft crimes, for example, could today be punishable by death, consistent with the Constitution. So that makes me wonder how far historical practices under Bruin, you know, really go.
I do think Bruin directs a look at the historical analogs, and many courts have said we've got to look at those, and the fact that prior felonies were punishable by death is relevant to this question and does, you know, in many ways decide the issue. I think happily here, because that issue is not raised at all, I don't think the court needs to get into it. I think the question of an as-applied challenge or the nature of the underlying conviction is literally nowhere in the briefs, and it wasn't raised to OAH.
I appreciate that
I
point.
just want to make sure that the court knows it doesn't need to get into that.
Suppose Mr. Chase had been convicted in the District of Columbia, and everything else is the same, except that after some 10 years, his conviction actually had been expunged under District of Columbia law. Would under the regulations and under your understanding of this, would the district still be within its rights to deny him a concealed carry permit despite that annulment in the district of his conviction?
Well, I think if my understanding of your question is right and my understanding of expungement is right, then I think the answer is yes, it would still be not denied for the same reason that this court has just said in Porter, which is that what the regulation requires is an order setting aside the conviction. It's not an order setting aside the consequences of the conviction or even removing all of the consequences of the conviction as with an expungement. And since the court has said in Porter, an expungement does not mean that you have not been convicted under the statute and that you're not subject to the felony disqualifier, I think something...
Only a set-aside on the grounds of your conviction was obtained unconstitutionally, or your conviction, there was insufficient evidence, or whatever. Only
Yeah,
that
I
would-
think there could
only
be
that
a...
would suffice. Does that, is that not, is that how we understand presidential pardons of persons convicted of federal crimes? Doesn't the presidential pardon dispose of all disabilities associated with the crime?
I'm not sure, Your Honor, to be honest, and I know that many pardon schemes, both federally and in the states, are different and have different proceedings
appreciate
and
that.
can be granted for different reasons. So I haven't done a deep dive on that or on, what various states' pardon techniques are. I would say that because they can be so specific, I think it would be wise for the court to really wait till you have a scenario where that arises to really dive into those questions, just because I know from what I have looked at that those proceedings can be sort of specific to each individual state.
Doesn't MPD have the ability to exercise some discretion here when they are, when they receive an application for a restoration of the right to carry a gun or to, or ammunition or any, to be licensed here?
Not on this question, Your Honor. So it might be helpful for me to explain how the statute and the regulations work together, because there is some discretion in the license procedure, but that
Yes.
comes into play later.
Okay, but I guess, as to the question of discretion, isn't part of that an examination of potential dangerousness or public safety?
Yes.
Address that in your response.
Yes, of course. So where we start, though, is looking, in this case, at the felony disqualifier. Here we have someone who has been convicted of a crime that carries a sentence of more than a year. And so in that case, that person is subject to the felony disqualifier. They cannot have a registration certificate. They can't have a concealed carry license. Now, these regulations do come into play, and MPD needs to look at them, because if someone comes to the court with an order setting aside the conviction, for instance, if it's an order on direct review or on post-conviction review that says this conviction was constitutionally infirm, this conviction lacked sufficient evidence, and it has now been set aside, what MPD will do is look at the record of the conviction, but then the order setting aside the conviction, and MPD will say, the felony disqualifier does not apply. That will not be a barrier. And then it will proceed with the rest of the analysis. And part of that analysis, once you get past the registration requirements, disqualifiers, the training requirements, is an exercise of discretion in terms of suitability. And so that's when, and there are regulations that govern all of this, that are interpreting statutes that help guide MPD's discretion with what it's looking at. But that comes into play after this question. And so I just want to make clear that, if MPD sees an order setting aside the conviction, like the kind we've been talking about, then the felony disqualifier won't apply. And that's the way that the regulation, I think, does some helpful work in helping to help MPD carry out the statute, and is, again, I think quite clear, because what you're looking at is an order setting aside the conviction, not the consequences of the conviction.
And MPD, in fact, did that analysis here.
Yeah, well, so what MPD did was it saw the record of the conviction, and actually the regulation was not brought up by Mr. Chase before OAH. So that question was actually forfeited by Mr. Chase before OAH. It was the ALJ and OAH who recognized the regulation and then explained why the restoration of rights orders don't qualify as an order setting aside the conviction.
So how did, why doesn't an expungement restore rights?
An expungement may in some ways restore some rights, but I think if the question is why doesn't an expungement set aside, meaning nullify or vacate a conviction, I think this court can look both at Porter, which has a section explaining expungements, but also at the Supreme Court's decision in Dickerson, which Porter cites. And the underlying most important reason is Dickerson explains that there is a difference between doing something to a conviction, invalidating it, vacating it, truly setting it aside, versus invalidating its consequences. And I think there's a helpful quote in Dickerson that I think is also quoted in Porter that I'll read for the court in case this is helpful. Expungement does not nullify the conviction because it does not alter the historical fact of the conviction, the legality of the previous conviction, and does not signify that the defendant was innocent. So I think
Porter went so far as to acknowledge that the actual effect of the Maryland expungement statute was to, quote unquote, wipe the slate clean, right?
Yes, and I think, the court in Porter did say there are some other effects of that conviction under Maryland law, even still after the expungement. But I think the relevant and helpful point for that here is what we have is certainly less than that, because neither the governor's order nor the Virginia court order purported to do or could have done anything to the conviction. All they could do was remove certain consequences of the conviction. And as the court—
Let me take you back a little into left field again, following up from my colleagues' hypotheticals. If this were not grand larceny, if this were a crime such as transporting a gun in a vehicle, basically the specific behavior that Bruin was targeted at and determined was constitutional, but there was still a conviction, and the person then came up for review, it would be your position, and this is two-part. One is if there was not a court order getting rid of the conviction, but there was a precedent that presumptively, or a city council had made this not a crime anymore, would that still be a conviction for purposes of this act?
I think so. If I'm understanding your question correctly, there still is a conviction.
No one has
that
done anything to the
exists?
conviction yet. The second
It
question is
still
going to be
exists.
if there is a court order
I see.
afterwards.
Yeah, I think if no one has done anything affecting the conviction, then I think the answer is yes. If your question is more about maybe something less than a felony, like some kind of misdemeanor offense related to transporting firearms, we would not actually be in this felony disqualifier universe. There is a separate disqualifier for weapons offenses, and that can encompass offenses even where the sentence can be less than a year.
And that was the focus of Porter, right, which involved that very crime.
Yes, and I think that question does come up sometimes, because sometimes those weapons offenses do carry less sentences. But of course, they're very significant to the council and to MPD in terms of determining whether someone is likely to misuse firearms in the future.
So the point is, even if there is precedent that has gotten rid of that violation, or if city council has even changed the law so that that's not a violation anymore, until an individual has sought a court order and gotten an order that removes that conviction from the books in some ways, or some way or otherwise sets it aside, that would still be disqualifying.
I think that's correct. I think, if something is no longer a crime, that may make it a lot easier for someone to get an order setting aside their conviction, either, post-conviction or maybe some other process for them to get rid of it. But I think, in this area, it is very helpful to have bright line rules. And I think this regulation sets out a pretty clear bright line rule. The order has to be one setting aside the conviction. And I think if the court has any doubt about what these orders have done, it can look in the appendix at pages 11 and 12 and the language of those orders, neither of which, again, purport to do anything to the conviction and, in fact, acknowledge that it still exists. Both the civil rights restoration says by reason of the conviction, and then the firearm restoration order says it appearing that the petitioner was convicted of a felony charge in Alexandria. So all the Alexandria firearm restoration rights is doing is granting a permit in Virginia for Mr. Chase to carry a firearm. And that is something that is well within Virginia's rights to do, but there is nothing in the law that requires the district to do the same thing. I wanted to also address briefly just section 224505. That statute, I don't believe is anywhere in Mr. Chase's briefing on this appeal. So I think that the import of that is forfeited here. But I think even broader than that, that's a defense to a 224504 charge, which prohibits carrying a firearm without a license. We're not in that context here. Here, what Mr. Chase was seeking from MPD was a concealed carry license to carry his firearm in any circumstances, whether related to his business or not. And so I think we're just in a different universe. And that's why it's the felony disqualifier in 72502.03 that we're looking at, and that's important here. And I think the 4505 question is not really relevant. I'm happy to answer any other questions the court has on any of the other issues. But if not, I think between the limited scope of Mr. Chase's constitutional challenge and what this court has already decided in Porter, I think this case is quite straightforward, and we would ask this court to affirm.
All right,
Thank you.
All right, Ms. Jones, you have a few minutes for rebuttal.
Thank you, Your Honors. A few points that the government made up. One was the issue of possession, and that a felon cannot possess a firearm in the district. In this case, the government also said that 4505 was not relevant, but the agency OAH conceded that Mr. Chase fell under that exception, which allows Mr. Chase to possess in the District of Columbia. So the issue of possession has already been.
Does the District of Columbia stop Mr. Chase from selling firearms in D.C.?
No, Your Honor.
So he's allowed to possess them to bring them into D.C. and sell them, right?
Yes. So he is allowed to possess them. And so so the issue is not a prohibition on possession. It's more so also a public safety matter. Mr. Chase, a licensed federal firearm person, can come into the district with an unlimited amount of firearms, say 100 firearms, and now, without being able to protect himself or his product, it creates a public safety issue for the district because the district won't allow him to protect himself in the course of his business.
So he could hire a security guard, right?
Yes, Your Honor, he could, yet it goes against, again, the holding in BOONE, which is proper purpose. The government is essentially saying that Mr. Chase can only carry for the proper purpose of his firearm licensing business, and that is unconstitutional according to Heller, as well as.
It seems like Broome would nod very positively at D.C. allowing Mr. Chase to pursue his business and have firearms for that purpose. I'm not seeing why that's unconstitutional.
Your Honor, just to pivot to one last point that I think the court should consider is that in the regulation, the argument is about set aside, whether it being innocent or not, but the regulation also says to consider judicial and non-judicial actions. And so the Virginia's restoration of rights would be a judicial action that should be considered when determining whether or not Mr. Chase should be issued a license. And Your Honor mentioned Porter, which this case is different because the government argued expungement, and in this regulation, expungement wasn't mentioned. And this court in Hickerson v. United States, when determining what the statutory language included, stated that it would not encompass grounds of innocence or anything that was not included in the statutory language. And in this case, the regulation didn't mention expungement, it mentioned set aside. And for the government to say that the court did not nullify the conviction, it nullified the prohibitations. And so it boils down to the word set aside. And so we're asking that the court remand this case. Thank you.
Thank you. We thank both counsel for your briefs and arguments today, and the matter is taken under advisement. All right, our third and final case this morning is TERESA CRUTCHFIELD versus DC Department of Employment Services. CAROLYN Boone Lewis Health Center versus Department of Human Services. I'm sorry, Department of Employment Services, et al. Okay. While counsel is coming forward, I would just note that in this matter, amicus briefs were submitted on behalf of 4 different amici, and none of the amici are arguing today. The court has reviewed and considered their briefs, however. All right, counsel?
Good morning, Your Honor, and may it please the court. Brandon Hancock arguing for the appellant, TERESA CRUTCHFIELD. So in this case, we're asking for,
Did you wish to reserve any time for
yes, I'll just reserve 2 minutes of my time.
Thank you.
So in this case, we're asking for a reversal of the CRB's decision that 1514, the statute for time to file a claim, prohibits Ms. Crutchfield's request for benefits. And there's several reasons for doing this. I would say that in the court's own words, this consideration is deceptively simple and litigiously prolific. And as you mentioned, Your Honor, there are several amici in this case which have been filed, and one of them actually points out that the way that the CRB interpreted the statute in this case is essentially a rewriting of the Workers' Compensation Act and how it functions. And so,
Now, there are several statutory
Yes, Your Honor.
provisions involved here, so can you be more specific?
so specifically with 1514, as it goes to that interpretation, we think that the interpretation as adopted by the CRB is incorrect, just based on the plain meaning of the statute, but also in practice, as well as in this court's own case law. It's been said that that would be an inaccurate reading of the statute. So 1514, in its own text, in the first sentence, it talks about filing a claim, and it says that the claim is for the right to compensation, whereas the CRB had said that essentially a claim is any new request for benefits, and that is clearly incorrect. Going on through
Well,
the
what it
text.
says, at least part of it, 321514A, once the right to compensation for disability or death under this chapter shall be barred unless a claim therefore is filed within 1 year after the injury or the death. And then it goes on further to say, once the claim has been filed, no further written claims are necessary.
Yes, sir.
Okay, and so you're talking about claims and claims for benefits, so can you,
Sure. So
Explain
just
that
to
distinction.
clarify, as we're discussing, the term claim as it's used in 1514 is specifically the initial, essentially, filing for the opening for adjudication of a case. Underneath that, you have either request for benefits is one way that the amici have referred to, additional claims, which I know we're getting away from in this case. And you also have, as the employer's brief has stated throughout, the term issues related to a particular claim. So
The statute doesn't clarify either of those points, does it? Does the statute use requests for benefits or further issues?
it does in certain places, Your Honor, and I would have to look through the statute to see specifically where it does.
Isn't that where we get a little bit of the ambiguity?
Yes, Your Honor, but if you're looking at the plain statute, the plain language of the statute, it says that the claim, as far as it pertains to 1514A, is for the right to compensation. So it's not asking for specific issues or specific requests for benefits. Like I mentioned, it's just the opening up for adjudication of those issues or those claimed to benefits. And that's essentially the exact language that this court used to describe that statute in Ferreira. And then also following up on that, essentially same language in just a second. CMP telephone, Your Honor. Additionally, when using the CRB's definition of what a claim is, this would essentially prevent a claimant from requesting any sort of benefits past either that year of the injury or year of last payment. So, for example, if someone has a scheduled benefit that gets paid out, you move on a year past that last payment for that scheduled benefit, that would bar any additional requests for, say, medical benefits, such as additional medical treatment, medication, other medical expenses that would be covered under 1507, which the employer is required by 1507 to provide.
You seem to be envisioning 1514A as essentially opening a file that can be supplemented for decades if needed.
If needed, yes, Your Honor. And that's consistent with how OWC actually does this in practice. So they have a specific form called a claim or application for claim. And so that's what's used to fulfill the statutory requirement in 1514A, is you file that claim for, or application for claim, and then that opens up a file with OWC, and it specifically discusses in the regulations that once that is filed, then OWC is responsible for maintaining that record associated with that specific claim throughout the length of the claim.
Was this a case in which payment of compensation was made without an award on account of her injury?
Yes, Your Honor, all payments were voluntary in this case.
Now, the statute says, this is 1514, if payment of compensation has been made without an award on account of such injury or death, a claim may be filed within 1 year after the date of the last payment. How do you interpret that language? She did not file a claim within 1 year of the stoppage of payment, if I understand correctly.
That is correct. However, Ms. Crutchfield had already filed her claim, and so based on the plain meaning of the statute, she wasn't required to file anything else under 1514A, where it says that if a employer is voluntarily...
Where do you see that in the statute, though, when the statute says if payment, I mean, the first sentence says the right to compensation for disability shall be barred unless a claim therefor is filed within 1 year after the injury or death. Now, that's except as otherwise provided in this section. The next sentence says if payment of compensation, the next sentence says if payment of compensation has been made without an award, which could be still there having been a claim, without an award on account of such injury or death, a claim may be filed within 1 year after the date. Now, it says may be filed, but there's no, I mean, what if it's not filed?
So if it's not filed, then you would look to the
sounds,
other
that sounds
exceptions,
like
yes,
a
Your Honor.
one-year limitation. If you wait more than a year and then file, it sounds like you're out of luck by implication.
Essentially, unless one of the exceptions apply. And
me?
specifically, unless one of the exceptions apply in the rest of 1514. But it also explicitly states the legislature
When you
did.
say the exception, what exception are you referring to?
So for example, if the employer has notice of the injury, and the,
I'm sorry, if the employer,
has notice of the injury, let me find the exact language. Yeah, where they have actual knowledge and have voluntarily paid for compensation, that would provide an exception to the one-year time limit in 1514A.
what do you, I'm sorry, just show me what you're reading. I'm not in that section.
So in my notes, I'm referring to the committee report here, which is the explanation for, in the 1999 amendments for not amending 1514A.
Sorry, I'm having trouble following you. Say it more slowly. What language are you referring to in this, in section 1514?
So that language that I mentioned came from the committee report for the,
Oh, it's not in the statute.
not explicitly.
Well, but at the end of 1514A, it says, once a claim has been filed with the mayor, no further written claims are necessary, right?
Yes, Your Honor.
Now, the CRB, I was going to ask you about that language. The CRB does not address that language in its opinion. Do you think we should remand this case in order to have the CRB explain how that language applies here?
I don't think that's necessary in this case to remand.
Well, it may be, because the question is, did she make a claim or not?
So there's,
In other words, is she claiming something for something new or not?
that's correct, Your Honor, but that also, because there's no award in this case, when you look at how the court has interpreted the statute for modification of award 1524, that until there's been an adjudication of the,
The parties
The
all
issue.
seem to agree that 1524 is not applicable here.
correct, Your Honor.
Let me ask you another question that has concerned me, that is raised by your recitation of this statute. Your brief on appeal says that Ms. Crutchfield filed her claim for benefits on November 8th, 2011.
Yes, Your Honor.
And I wanted to ask you whether that is correct, because the brief does not cite anything for that statement. And maybe I've missed it, but I haven't found any November 8th, 2011 claim filed by Ms. Crutchfield in the appendix or in the record on appeal. Now, maybe I missed it, so if it's there, I'd like you to tell me. But if it's not there, where does that leave us?
That's correct, Your Honor. We don't have the actual form in either the appendix or the record.
So what's the
However,
basis for saying that she ever filed the claim?
I believe, and I can double-check this, is that the basis for that is in the ALJ's finding of facts.
Yes, I think you're right, that if I remember correctly, that the compensation order may mention that, but I'm just wondering if that is correct. The ALJ may have gotten that from the brief and just accepted it as true. I'm not sure it is true.
So, like you said, it's not in the record, and it's not in the appendix. However, that has not been disputed, and when we brought this case to the ALJ most recently, that was an issue that was not contested, whether or not there was a claim filed under
I mean,
1514.
do you have in your file a document that purports to be a claim from November 2011?
From what I've seen in our file, I don't remember seeing it.
It
However,
was not represented by you at that time, I think.
correct, Your Honor.
Well, I mean, it's a little unclear to me what the significance is if, in fact, there is no such claim in the record. that undercuts your argument that she, I mean, if in fact there was no such claim, a claim is a formal thing, right?
Yes, Your Honor.
I mean, it's not enough to say that she went to her employer and said, I'm injured.
So that's one of the exceptions, if there was actual knowledge.
Actual
of injury.
knowledge.
Yes, Your Honor. And then voluntary
But I don't know
payments.
where that, nobody's raised the question, the exception of actual knowledge as a,
As I look at all these different statutory provisions, I was asking earlier about 1514, but when I look at the statutory scheme, 1505 is the commencement of compensation. 1508 is commencement of disability. 1513 is time for filing a notice of injury, and 1514 is time for filing claims. What is the difference between all of these different timeframes?
So,
We're here trying to determine whether the subsequent or second injury in 2012 was, what, a new claim, a new commencement for compensation?
to be clear, it's the same injury throughout, and it's the same claim as far as being totally disabled.
Okay, so tell me what the difference is between commencement of compensation and commencement and compensation of disability, time for filing of notice, time for filing claims. How do you differentiate each of those stages under the statutory scheme?
So starting with the notice of injury, since that's the initial step that you would take when.
So the 1505 and 1508, which precede, those provisions precede notice of injury, what do those provisions mean?
So specifically with 1505, the legislator intended that to be a cap on partial disability benefits. And so that's explicitly what it says in the text as well as in the rationale for that statute. And it was a measure added in to limit the costs related to partial disability benefits.
So that stage wouldn't require the petitioner to do anything, or the person seeking compensation to do anything?
It would still, at some level, either whether it's voluntarily on the behalf of the employer or through filing of an issue or request for benefits, still ask for those benefits.
Okay, but they don't, nothing is filed, is what I hear you
Correct,
saying,
Your Honor.
until
Nothing needs to be filed under 1505.
1514.
So 1514, like I mentioned, it's been implemented as the single claim form, and that's filed at the, as it says, either following the injury or the last payment.
And so this is what I described in our colloquy earlier as akin to opening the file
Yes, Your Honor.
related to the injury.
Correct.
So at the time of what I call the second injury or re-injury in 2012, where were we on this scheme or timeline?
So Ms. Crutchfield had already filed her initial claim under 1514A, and at this point, we're getting to where the employer claims that they're terminating benefits, but essentially, she's still disabled, Ms. Crutchfield is still disabled. Ms. Crutchfield is still seeking payment of medical treatment as well as the disability payments for lost wages. As far as having anything filed, nothing is still required at this point. And that's because one of the goals of the statute itself is to be able to have a less formal or quicker procedure just among the parties in resolving these issues, as opposed to having to do that in court or through the administrative body.
You said nothing is required for the party seeking compensation to file upon the re-injury, new injury, exacerbation of the injury, however you want to characterize it.
So to be
She
clear.
did file something.
She did, yes. So she was asking for adjudication of certain issues. However, I just want to be clear that this is the same injury. It's all just to her back, which she sprained in March of 2011. And so she's still dealing with that injury even today, but at December 2012, when
I'm sorry to keep interrupting, but I just want to make sure I understand. So this was after a point in time where she went back to work on light duty status
yes, Your Honor.
and exacerbated, something changed in the injury or the pain that she was feeling. I thought it was because she ended up lifting something and making it worse or making it hurt again, and
So essentially, she attempted to return to work on light duty. They put her in a position that was not compliant with her light duty restrictions. And so as she was doing that job, essentially it was proven that she couldn't do it within her light duty restrictions. And during that time, there was, as you mentioned, I think there was that she actually fell. And I don't know if that re-injured her back or exacerbated it, but she was still essentially found to be limited to certain restrictions when she returned for examination after that incident. And at that point, for whatever reason, that physician had decided that she should not return to work.
right. So what I'm getting at is at that point in time, she files something else, doesn't she?
So if it were a new injury, then she would file a notice of injury. If it were,
What did she file and under what theory? That I'm just trying to
so she,
understand your argument.
so going to specifically what the CRB is basing its decision on, as far as 1514A, that was filed in the fall of 2011.
You say, but
So-
there's no record of that.
Correct, Your Honor.
Am I correct that, I thought something else was filed in
So she had
2012?
she requested informal and then formal adjudication processes. So those were filed, but those are not necessary for her to either preserve her claim or for the resolution of those issues.
So how would you characterize it? I guess I'm not antithetical to your perspective. I'm just trying to understand what it is. When she filed for further adjudication in 2012, what was that? Your interpretation would be that it was updating her file that she had opened previously under 1514A. Is that how you?
Correct, yes, because the employer had stopped paying her benefits. And so she was essentially seeking to have those benefits resume.
I think I missed something. What are you saying she filed in 2012?
She filed a request for both, well, in 2012, it was the request for an informal hearing, and then following that was a request for formal hearing.
And in the fall, there's a request what? Speak up, please.
So 2012 was the request for an informal conference, and then following that was the request for formal hearing.
Oh, okay. So basically, if she did not file a claim in November 2011, then you would agree that she has not filed a claim since then.
Correct, Your Honor.
Okay, and then she's out of luck.
But as the statute says, as you read earlier, there's actual knowledge of the injury and the,
Nobody in the briefing has relied at all on this actual, to my knowledge, has relied at all on this notion of actual knowledge of an injury as excusing the failure to file a claim. Am I right about that?
you're right about that in the sense that that is not argued.
And the CRB never relied on anything like that.
That's correct, Your Honor.
Do you understand the reasoning of the CRB as to why Section 1505 is not applicable here, which is your position, that
Yes,
Section
Your Honor.
1505 is not applicable here?
So So I'd have to reread the CRB opinion to be specific as to their rationale for finding that it doesn't apply.
All right, why do you think Section 1505A, Section 1505 does not apply here?
So we have several reasons why we think it doesn't apply. The first one being that 1505B is specifically for partial benefits. Additionally, when you look at the last sentence of 1505B, it states that the limitation there is 3 years to reopen a claim or reopen a file after the termination of benefits due to a change of condition. And we're not asking to reopen because the claim was never terminated, or benefits were not terminated, and there was no change in condition for Ms. Crutchfield.
Was no change. Yeah, well, there's another reason why I think I have difficulty seeing why 1505 applies here. The relevant portion of that statute says an injured employee shall have up to 3 years after termination if non-scheduled benefits to reopen his or her case due to changes in condition. And non-scheduled benefits are defined specifically to mean benefits for partial disability. And specifically one not enumerated in 32-1508. So that would seem, she's not claiming a partial disability.
Correct, Your Honor.
She's claiming a total disability, either temporary or permanent, as the time period may be. And why did Ms. Crutchfield not return to work the second time her employer offered her a light-duty position? Does the record indicate anything on that?
So at that point, I think it was, she had returned to work on light duty. It was at least early summer. I think it was August is when that
It
happened.
didn't work because they didn't really give her a light duty.
Correct, and then
she
she had,
re-injured herself.
she had a subsequent examination where they said that she
So
could
a
not.
few months go by, and then the employer says, okay, we're willing to give you, because this is what led the employer to terminate the payment, to cease the payment, the benefits to her.
Correct.
Compensation benefits. Anyway, they continued paying medical benefits for a few years.
I believe so. I'd have to double check to see if they're the ones that paid them or not, but yes.
I mean, why did Ms. Crutchfield not return to work the second time her employer offered her a light-duty position?
So after
Because her failure to do that is what triggered the termination, evidently.
after the incident that we had discussed previously where she had returned to light duty, she was written off from returning to work at all. She had no restrictions. It was just don't go back to work.
So your position was, and this seems to have been the employer's position too, that as of that time, she was suffering from at least a temporary total disability.
That's not the employer's position
Well, that's what
because
they said when they filed the form concluding the payment of compensation.
I just know that they wouldn't have offered light duty if she was totally disabled.
Yeah, they were being inconsistent.
Sure.
We need to make a determination here as to whether Ms. Crutchfield was totally disabled on a permanent basis.
So those determinations should be decided in the first instance by the ALJ. So we're not asking this court to address those issues.
Do you believe that Crutchfield was totally disabled when she was taken off work following her fall?
I do, yes.
So her fall, suppose during her fall, she broke her leg, an injury distinct from what I understand were her back issues. Would that necessitate a new claim being filed because it was a new and different, arguably a scheduled injury as opposed to a non-scheduled injury?
So I would have to go back to this particular part of the statute, but I believe it's in 1508, where it has specific instructions for when there's either a consequential or aggravation of an existing injury.
Okay, so wasn't this an exaggeration of an existing injury, if you leave aside my hypothetical about the broken leg, where she goes back to work on what was supposed to be light duty, but her duties required her to do work that exceeded her physical capabilities? And so she falls and re-injures her back.
So her back was still in the same condition before the fall and after the fall. It's the fall specifically was just a consequence of her returning to work outside of her limitations.
Why do you resist the characterization that it was a re-injury or an exacerbation? Is that because that would trigger 1508 provision?
I don't believe so, but which provision in 1508 are you referring to here?
Well, I'm just wondering why you resist the characterization of her injury after going back to work on light duty as one that exacerbated her existing injury, made it worse, re-triggered it.
So I don't have a factual basis for believing that, but I can see that it's definitely possible.
One further question to go back. We talked about what you believe to be was her claim in November 2011. Was that a claim for partial or total disability?
So one of the issues with the CRB's interpretation of that filing of a claim is you don't specify what type of disability you're requesting. You're just notifying that there is a compensable disability, and then that's why it's this general term for opening up the adjudication. So that would be something, an issue that's requested underneath that claim. So
How do we decide the difference between a claim? I mean, maybe I should step back. I understand your position to be that when she later requested benefits, years later, that was not a claim, it was a request for benefits.
correct.
How do we, it seems like our case law has not been consistent in its understanding of what constitutes a claim. What is the difference between a claim and a request for new benefits that have not been previously provided or that have been terminated?
So as stated in the statute and the case law, and just in practice of how everything gets implemented, the claim is just that original, essentially analogous to a complaint.
Claim says, I've been injured and I want benefits.
Correct, Your Honor.
Okay, so she gets, let's say she filed, let's assume for the sake of argument, she filed such a claim in November 2011. Okay, she got benefits, and then the benefits were terminated in, I forgot the date. When was it? Sometime in 2012, I guess. Is that right?
So they had offered
Yeah,
her the
December,
position.
right, it was December 2012.
Yes, Your Honor.
So, years go by, and she then says, well, I'd like benefits now to be resumed. Why is that not a new claim when benefits were terminated and she did not object to the termination at the time?
So at least in part, it's because it is the same injury that occurred in 2011 that she's requesting benefits.
But how do we know that just because it relates back to the same injury, that it's not a new claim?
So,
I'm trying to get a clear notion of why it's, of what the distinction is Because our case law does not seem to answer this question. It seems to go both ways. You've cited C&P, which I think can be read to support what you're saying, but I think other cases suggest otherwise, both before and after CP.
I think one of the issues in answering that question is procedurally, where is the request for benefits? So
Procedurally what?
where the request for benefits comes in. So, for example, when determining a new claim in Millhouse, they did that because there was already a compensation order in place that didn't address that specific request for benefits. And so they had found, because it hadn't been adjudicated, it was not part of the previous claim and therefore was a new claim.
This gets to something that the CRB said, that I guess I was going to ask you about. We sort of touched on it before. The CRB said that if a new claim for benefits does not require a review of an issue previously decided in the previous compensation order, then Section 32-1514 applies, and the claim must be filed within 1 year from when the claimant was aware or should have been aware of the injury. Now, do you agree with that statement by the CRB?
We agree with that statement, and we think it's consistent with both 1524 and also 1505, where it mentions the reopening of benefits or compensation
Yeah,
after the termination.
Right. I mean, I think, right now, I'm just focusing on 1514. What I'm wondering is how that formulation by the CRB applies to Ms. Crutchfield. It seems like her claim that she made in 2022 did not require a review of an issue previously decided in the previous compensation order. And that seems to suggest that it had to be filed within 1 year, after she was aware, or should have been aware, of her injury, which it clearly wasn't. She was well aware of her injury for a number of years.
Right.
So that seems to, but maybe I'm reading this wrong. So I want to understand your.
No, I believe you're correct in that reading, Your Honor, but going back to the specific case here, she had filed the initial claim form. And again, that was not contested at the beginning of the proceedings in 2022.
It just seems funny that if she files a claim, the claim is, assuming she filed it in November 2011, the claim is honored in the sense that the employer provides benefits. And then the employer, a year or so later, says, okay, we're terminating the benefits because you're no longer eligible, because you refuse to accept light-duty employment, okay? Then, and she doesn't object to that, then you would think that if she, years later, says, well, I've been injured and I'm not better anymore, in fact, I'm worse, I'd like to make a claim for benefits. That feels like a new claim, doesn't it? Because you have this sort of de facto determination in December 12 that her entitlement to benefits has ended.
So it's not a new claim in the sense that there hasn't been a final adjudication or final order on the previous claim
Well, but
related to the specific injury.
if this was a new injury, essentially, and her benefits that she was receiving from the initial injury had ended, she was still within the time frame of the 1 year period, if I'm calculating correctly, to file a new claim under 1514A, right?
If it's a newer injury, then yes. If she filed it within that 1 year under 1514, that new injury would be a new claim.
And is a re-injury or exacerbation of an existing injury considered a new injury or not considered a new injury?
I don't believe so, Your Honor. And if there's no further questions, I will turn it over to the appellee.
Okay, thank you. And I think you reserved a couple minutes for rebuttal, is that correct? Okay, thank you. Ms. Petrella?
Good afternoon, Your Honors.
Good afternoon. Almost.
I'm a little ahead of myself, okay. Okay. We are here today asking Your Honors to try to make sense of several statutory and regulatory provisions of just one simple act. And I think the briefs and some of your questions today have really highlighted one of the issues, which is that the way the act uses language, the way practitioners use the language, and so then therefore the way the court uses the language in its decisions are not consistent. But what is consistent through the law is when we're looking at how to interpret these statutory provisions, we need to start with the language, we need to look to the legislative intent, which includes especially looking at the overall legislative scheme. And most importantly, no provision, no interpretation of a provision should render another provision superfluous. And that today is why it is our position, my client's position, that 1505B, that last little line of 1505B, acts as a statute of limitations, and Ms. Crutchfield's benefits were claimed for relief was filed late, or in the alternative that the Compensation Review Board was correct, and that 1514 is a one-year statute of limitations, and that Ms. Crutchfield's new claim for benefits was untimely. I do want to make clear.
Can you,
Yes.
would you mind just, I'm trying to find in my notes the language of that last line of 1505A, but if you have it.
The language, Your Honor, of 1505B is specifically, an injured employee shall have up to 3 years after termination of non-scheduled benefits to reopen his or her case due to changes in condition.
All right, didn't she do that or attempt to do that in 2012?
So yes, that,
After
when.
she's exacerbated the existing injury?
So I do not know that the medical records or the file history show a physical exacerbation of the condition, but what did change, because disability is an economic concept, so it did change her condition because disability was changed by light duty being offered and her declining it. Once she is given restrictions and light duty is offered, she is no longer temporary and totally disabled. Even if her physical condition may be equally as bad as it was yesterday.
But she was, I guess she was working under the initial restrictions that she was given for light duty when she.
Correct.
Okay.
She worked briefly, and I will state, allegedly,
What
she worked.
happened there?
Allegedly, she worked briefly, because one of the underlying issues of this is everything that went down in 2012 with her employment, we have nobody to turn to but her, because the employer, by the time she resurfaced in 2022, seeking benefits all the way back to 2012, the employer no longer existed. So Ms. Crutchfield alleges that she returned to work and attempted light duty work, and she alleges that the light duty work was not within the restrictions. My client, my employer client, no longer exists, so we have no evidence to dispute that because they no longer exist. And then she did go back out of work, and temporary total disability was resumed.
May I ask you a question about the sentence that you're relying on in 1505A,
Yes.
1505B? That's the last sentence. As you say, an injured employee shall have up to 3 years after termination of, quote, non-scheduled benefits to reopen his or her case due to changes in condition.
Yes.
Now, non-scheduled benefits is a defined term.
Yes,
It seems to refer to benefits, although the definition is not clear. It seems to refer to benefits that are for a partial disability not enumerated in 32-1508. But when the employer terminated her benefits in December 2012, the employer stated that the benefits being terminated were total disability benefits, not partial disability benefits. That seems like an indication that the last sentence of subsection B doesn't apply.
Your Honor, sorry, I just wanted to double check the
If you
language.
can find out
Your Honor,
I can read it to you if you give me a minute.
so the issue, and you noted yourself that the definition of non-scheduled benefits is unclear. And the problem with the definition of non-scheduled benefits is if you read the definition as how it's written, then there are no such benefits in the
Leaves out the
Act.
words benefits for.
If we look to partial disability benefits enumerated in 1508, all of the existing, what I think myself and my colleagues would consider partial disability benefits, all of them are enumerated in 1508. So if we look at it that way, then there are no such benefits
Yeah,
that.
I think what is meant is there are certain types of partial injuries that you just get a lump sum or a defined payment for if that's the injury, loss of an arm, for example. And then there are others, and all those are listed. There's no issue, and because the actual award is specified there, it doesn't really raise the kinds of questions that are raised when a person is partially injured in other ways. And I think that's what they're getting at.
So to be clear, Your Honor, the disability benefits that you are referring to it's 1508 subsection 3. Those benefits are not inherently or automatically paid in a lump sum.
Right.
Those are also paid.
It can be paid out over time. I agree.
They can also be paid out over time. So again, if we're talking about 1505B, or if we're talking about all partial disability benefits not enumerated in 1508, if we're talking about the 1508-3, those are obviously in 1508. If we're talking about the other, I forget the subsection, but the partial disability wage loss benefits for different body parts, that is also enumerated in 1508. So the problem with the definition and the provision is when we try to see what partial disability benefits are not enumerated in 1508, if we're talking about indemnity benefits, money to the claimant, those are all enumerated in 1508. So we're left kind of with, then what benefits are we talking about? And I believe both sides in their briefing agree that we must be looking at benefits not in 1508, which would be medical benefits, vocational benefits, I believe those, and death benefits, but those are kind of separate to this question regardless.
So when
Putting
was the
that
last?
aside, what is your understanding of why, of the commission, of the CRB? I'm getting the CRB,
Yeah.
right, of the CRB's rationale for saying that 1505 did not apply here.
So I'll note that they didn't really give rationale. To the extent that they did, they simply stated that it's inextricably intertwined with 1524. That is their rationale.
There's a further explanation in the concurring opinion, which, since it's by two commissioners, actually sort of counts like a majority opinion.
That is true, Your Honor. The problem with all of that, though, again, is to go back to the very beginning of statutory construction. We cannot interpret a statutory provision in a way that renders another provision superfluous, which is to say that 1505B cannot mean the same thing as 1524, both from that basic foundation of statutory interpretation, but then from other basic foundation of statutory interpretation, which is to say, if the legislature, let's say the legislature thought 1524 was so important that they wanted it in the act twice, there's absolutely no explanation for why they used different wording, different terms, and added a term of art that does not exist.
Let's see, so 1524 applies when there's a change that affects a finding of fact made in the original order, right?
Correct. So let's say in this case, if the formal hearing in 2012, if it actually went forward and a compensation order were issued, and let's say that, and Ms. Crutchfield at the time was seeking temporary total disability to present and continuing. Let's say that the administrative law judge denied her claim for relief and found that she was not entitled to temporary total disability. If she wanted to seek to present and continuing, because that's to present and continuing, if she wanted to seek a reversal of that, there's obviously the appeal process, but separate from that, she could also, if something physically changes or the light duty, say the employer went out of business and so there is no longer the light duty that she could have taken, and she files for modification because she would be asking the agency, I know you have already found that I was not temporarily totally disabled, but I'm asking you to undo that based on things that have changed. And that's where 1524 comes into play. And 1524, so that's important, 1524 is not a statute of limitations. It is an expansion of a claimant's rights. I don't really know that there's any other area of law where a party has so much capability and ability to ask a court or a board or an agency to redecide an issue that's already been decided, but workers' compensation in 1524
It's
explicitly
sort of basically going
gives that.
back and saying you made a mistake. Subsequent events show you made a mistake.
Correct,
But there seems to be general agreement that 1524 does not apply here.
correct.
So that leaves us with either 1505 or 15. Now, your opponent argues that there's a difference between a claim and a request for additional compensation or additional benefit, I should say additional benefits or new benefits. How do you respond to that?
Claim is used, again, in the act by practitioners, and so therefore by the court because of how it's presented to
It's not
them.
a defined term.
Claim is used in both ways. Claim is often used by attorneys we speak to. When we speak to the claimant filed their claim, we are referring, often when we speak to that, we are referring to those initial claim forms. The employees, I think the employee's claim form and the employee's notice of claim, they're essentially the same form. There's very little difference between them.
Is that different from what you file under 1514, or is that what you mean when you say the application?
So that's what I'm talking about, is we sometimes, so that claim form, I think that comes actually out of 1513, that written notice. And there is absolutely evidence in case law, and I think it comes from attorneys, of that being referred to as filing the claim.
Which one, the time for filing claims, 1514, or the 1513 time for filing a notice of injury? Or are you using those?
So, sorry, what I'm trying to say is sometimes we talk about, the attorneys use the phrase claim filed when what we are actually talking about, if you look at the statute, the notice under 1513. And so I think if you go through the case law, there oftentimes the agency and this court uses that same language when you actually look at the statutory revisions, what is actually being talked about is that notice under 1513. And it's essentially, the confusion has gotten there because No offense to myself and my colleagues, get a little lazy in our language sometimes. But if you look at what 1514 says, and you look at how claim is being used throughout the act, the courts, or the CRB's interpretation of what 1514 means, I believe, is correct. Going back to what my colleague stated about once you file the Form 7 and 7A, once you file those forms pursuant to 1513, his argument that that is the 1514 claim filing and you never have to file anything ever again, I think he was being questioned about it, and what happens when you're seeking new benefits? You have to file a claim for those benefits. And that's exactly what Ms. Crutchfield did back in
The same claim form?
So you would file specifically, you would not be filing the Form 7 and 7A, which is, I believe, the notice requirement under 1513. But what you do have to file is you can file either an application for informal conference or an application for formal hearing, because you can skip the informal conference. It is up to the party seeking the benefits. But that is them making a claim for benefits, and that is them making a claim for compensation. And that's exactly what Ms. Crutchfield was doing in 2012. And again, we're not fully clear why the formal hearing didn't go forward. But that's exactly what she did in 2022, almost a decade later, is file a claim for benefits, a new claim for benefits. Yes, from that same initial 2011 injury. So yes, she did have her notice form 7 and 7A, those pursuant to 1513, those were filed back in 2011.
Did she file those again in 2022?
No, she just
What
filed.
did she file in 2022?
She may have filed it, yes, she filed an application for informal conference, and the parties proceeded to an informal conference. And then from there, one of us, whoever lost below, I do not recall.
So you, do I understand correctly? I'm a novice here, so bear with me. Back in 2011, it is asserted that she filed the claim form required by 1513.
Yes.
Do you concede that she did that? Because, do you know why we don't see it in the record anywhere?
Your Honor, I am confident that I would have checked my file to make sure I had a copy of it. I haven't looked at it in a while, but I'm going to rely on my past due diligence and say that when she resurfaced in 2022, I took a look through and I must have seen a copy of that, or else I
appreciate
would
that.
like to think that I would have raised that issue.
If you want to send a copy to the court, we'd be delighted, I suppose. But okay, that answers one question. And so if she did that, it sounds like you're saying that she did not have to file another 1513 form to comply with Section 1514 A.
Correct. If she, and to go back to those two.
Even though that refers to a claim.
Right, so you have to file a claim for benefits, which she did file. She filed an application for informal conference, specifically making a claim for temporary total disability and permanent total disability benefits. So she has to file that, because otherwise, and so.
She did, I'm sorry, maybe I misled you
Yeah.
with what I was saying. She did file, we're positing, a claim in 2011.
Yes.
And so that got things going. How do you interpret the sentence, once a claim has been filed with the mayor, no further written claims are necessary?
The best interpretation I have, Your Honor, is that, yes, once you file your claim for the benefit sought, you file either an application for informal conference or an application for formal hearing seeking temporary total disability, seeking medical treatment, whatever it is you're seeking. You do not need to refile something seeking those benefits. If you're filing a claim for new benefits, you file one application and you do not have to refile. And
So if she's filing, if she's not having to file a 1513 claim when she wants new benefits, Why was she out of time, in your view, here in 2022?
Because the 1513 filings are just notice of the injury. What she filed in 2022 was a claim for benefits. And so those notice, the Form 7 and 7A that give notice, those do not start any adjudication process. There is absolutely no adjudication process made. And you also should be filing those even if you do not think you need any benefits at this time, because you might need benefits. But if you need benefits or you're seeking benefits, whether they be indemnity benefits or medical benefits, that for some reason an employer and carrier are not providing you, the only way to do that, or the only way to solve that disagreement between you and your employer is to file a claim for benefits, either an application for informal conference or an application for formal hearing. There are two different sort of hearing adjudication procedures, and the only way those get started is by somebody, a party, specifically filing a claim for benefits triggering the start of that adjudication process.
So help me square that with the CMP telephone, where we said that a claim as referenced in 1514 must refer to the initial claim filed under presumptively section 1514 and not to subsequent requests for disability. That's at page 696. That seems to imply that 1514 wouldn't bar those subsequent claims and they all relate back to the original, much like the theory that your opponent is pushing.
I don't think we can square it with CMP.
Okay.
I think if 1514 is interpreted the way that the CRB stated, which I agree it ought to be, then I do think that the court in CNP got it wrong. And I think that goes back to what CMP stated is, you know, the initial notice, Form 7 and 7A, must be the only claim form that 1514 is talking about, because there is no other such claim for compensation in the Act. And that, I think, is where they were wrong. I think they missed that and perhaps didn't read through enough of what initially looks like unrelated statutory provisions until you look at the language they're using and what they're talking about, and you realize, oh, in order to make these claim procedures work, 1520, the claim procedures, even if you look back at 1513, it references in D2, the mayor can excuse the late notice, the late written notice, unless objection to such failure is raised before the mayor at the first hearing of a claim for compensation in respect of such injury or death. So that claim for some compensation is something separate. I believe it's 1520, which is the claim procedure, the procedure for how you adjudicate a claim for benefits. Now, that's specifically just the procedure for the Administrative Hearings Division. The informal conference procedure, I think, might just be in the regulations. But if you look through the Act, there are actually a lot of different ways in which claim is referenced and claim for compensation is used. So I think that's what CMP got wrong. And again, I think CMP, the court, and the lawyers that, you know, because the court has to rely on the lawyers bringing the argument to them, I think they probably didn't go out and look to all of the other provisions, because at first glance, they seem irrelevant to the issue. But when we're tasked with figuring out what non-scheduled benefits could possibly mean when it seems to suggest something that doesn't exist, and when tasked with trying to figure out what definition of claim are we using here, and when we're being tasked with trying to figure out 1505B and 1524 may appear similar, but they must be something different. In order to answer those questions, you do really have to comb through absolutely every single provision of the Act and see exactly how these words are being used elsewhere in the Act, because something might make sense in our little narrow tunnel that we're looking at, but what happens, how does that upend, say, the case law on attorney's fees, and when attorney's fees are assessed against the employer versus paid out of the claimant's pocket? That itself comes down to what you consider compensation and what you consider the time for when a claim was made.
So let me just, again, I want to be sure, because a lot turns on the interpretation of 1514, since that's what the CRB relied on. So if I understand you correctly, the first sentence, when the first sentence says, "The right to compensation shall be barred unless a claim therefore is filed within 1 year after the injury or death," there, the word claim, are you saying that refers to a claim under 1513?
No, I'm saying that refers to a claim for benefits. So if you're
Oh,
seeking.
so you're saying it does not apply to a claim for benefit? Oh,
So what I'm saying here is you have 1 year if you are asking to receive benefits, you have 1 year from the
okay.
injury or the last payment.
If that's true, then what is the meaning for once a claim has been filed with the mayor, no further written claims are necessary?
Again, Your Honor, I agree it's not the best answer, but the best sense that I could make of that would be that once you file a claim for temporary total disability from March 11th, 2011 to present and continuing, you don't need to refile
Well, I
that.
thought you said it doesn't really specify whether it's temporary, what kind of disability it is, whether it's partial or total or.
No, we're talking about when you file a claim for benefits, or also could be described as a request for relief. So when you're filing an application for informal conference or an application for formal hearing, you do have to be specific in what you're seeking, because that triggers adjudication, and my client has to know, what claim are we defending against? Like, we understand that this was your 2011 back injury, but what benefits are you seeking that we have to defend against? You have to tell us in your application.
So your understanding is under 1514A, you have to ask for benefits within a year of the injury.
Or the last payment. And again, I would specify that that is the time for
Well, I
filing.
want to get to that second sentence.
Okay.
But
Yeah.
the first thing you have to do is file a claim within a year after the injury.
Or the last payment, yes.
Okay. If payment of compensation, if you filed such a claim at the outset, and you get some benefits, and then the benefits are terminated, the second sentence you're saying, the second sentence require you to file another claim within a year if you want the resumption of benefits?
Yes, because now you're seeking new benefits. You know, my clients,
And so you're saying you have to file that second claim for renewed benefits if they've been terminated, even if you had first filed. And that's because there's nothing formal about this claim. It's just a claim, a request. A claim is just.
right, it's,
As you interpret the statute, a claim in 1514 is not the 1513 claim. It's just a request for benefits.
1513 is putting the employer and the agency on notice that an injury occurred. But you may not need anything, or there may not be a dispute because my client may be voluntarily paying. But if you are making a claim for something because you are saying you need it and it's not being provided by my client, in order to actually adjudicate that, you have to file something separate. You can't just call up the agency and say, the employer and I are fighting. You have to file a claim for those benefits that you are seeking that my client is denying.
Why does that sentence begin, if payment of compensation has been made without an award? In other words, suppose there was an award, but then you get to the point of a last payment, and you think you're entitled to more benefits.
So why does it say if payment made without an award?
Why does it limit that, why does it have that limiting language, if payment was made without an award? What's,
Well, if we're talking about changing payments made pursuant to an award, that's modification of an award under 1524.
you say that's.
Yeah.
okay.
But where there has been no award, because my client, in this case, there was never any award of benefits because my client agreed she was injured, agreed that it was work-related, and agreed for a period that she was unable to work. So voluntary
Okay.
payments were made.
Now, with that understanding of this language, tell me again what that last sentence is supposed to mean. Once a claim has been filed with the mayor, no further written claims are
Yes.
necessary?
Once.
Because this is what they rely on.
Yes, so once a claim is filed, so let's say the claim was filed for temporary total disability from March 2012 to present and continuing, she did not have to file another claim seeking those benefits because it was filed. The adjudication process has kicked off, has started. If the adjudication process comes to an end unfavorable to her, or I guess in this case, just came to an end in a way that we're not sure how, if she's seeking benefits again in the future, that's a new claim, and that's a new claim for benefits, but she doesn't have to
So let me ask
refile.
you for one clarifying thing on this, because I wonder if I'm getting something confused myself.
Yeah.
At least one of the amici cites our 2009 case, Combs v. Department of Employment Services,
Yes,
which involves there was a 1991 and a 1996 accident involving buses.
yes.
And the 1996 claim was time barred because there was no claim within a year based on that. But on the 1991 claim, they had filed for total, I guess, TTD within a year of that. And then we affirmed the CRB saying that, yeah, so they were good to go in 2003 to file for temporary partial disability.
The explanation on that one would be, nobody asked, wait a minute, is that timely under 1514?
And that seemed to be squarely the question. They said that the 96 claim was not timely, the 96 accident-based claim, but the 1991 one would extend. And I get that our case law is, at least in this area, as Judge Glickman described, or perhaps more generously than I will, kind of all over the place in certain respects.
So I guess my reading of it, and I did review it a couple days ago, but my recollection of it at the time was that the court did squarely address whether the claim for benefits to the 1996 were timely. I did not recall, or I guess what I recall from it, from when I read it last, was that nobody actually asked. Like, everybody agreed that the 1991 accident, those forms were timely filed. And that probably is a case where it was called, they filed their claim. Going back to what I said before is we get lazy in the language. So that might be, I'm sorry, that might be the question that you're asking. Is yes,
You're saying
I
not
believe
that
the
the-
language did say, that claim was timely filed. And I think if you're looking at it, they are talking about those initial notice, forms, Form 77A, that I believe are actually the 1513. And I think that is another one of the situations where we have used claim in different ways, and we have been sort of, again, this is on my side of this, the way that we present it and we talk about it, we have been inexact in the language that we're using. And I think you can see it through the briefing. Even as we're trying to argue this, you can see some parties using the language in contradictory ways. And so I think that is what was coming in that case. And then they didn't actually address, hey, actually, do we have to look at whether the new claim for benefits was timely, since we accept that the forms, the initial notice forms were filed timely. I do think that is something that would have to be sort of carefully clarified. And then I just briefly thank you for your time, but would note that there is also the doctrine of latches. Again, my client, by the time this came back up, literally no longer existed. So I think that's a perfect evidence of prejudice, exactly what was going on in 2012 and ongoing. Thank you.
Thank you. Mr. Hancock, I believe you reserved a couple minutes for rebuttal.
Thank you, Your Honor. I just want to clarify a few points, first of all, when it comes to the statutory requirements, both of 1513 and 1514. So in 1513, the title of that specific provision is notice of injury. And as the Employers' Council mentioned, That is done by filing a 7 form, OWC Form 7. If you get to 1514A, that's where you have the Form 7A, and that's the claim, the application for the claim. Additionally, when you look at the statutory history, as the legislature was adding 1505B to the statute, it also revisited the idea of 1514A and what that requires. And it made this statement following both its findings in Ferreira and CNP Telephone, which both say that a claim is just that one filing that initiates the adjudication process. The council said this in their committee report: "The committee hereby makes clear its intention that an employee should not be barred from entitlement to compensation where there was actual notice of the injury and the employer was voluntarily paying compensation or or paid for health services." It says, "In these instances, the employee should not be barred from entitlement to compensation for failure to timely file a claim." Additionally, we did discuss,
Well, wait a minute. You agree that payment of compensation had been made in this case without an award. Is that correct?
correct, Your Honor.
So the statute says explicitly a claim may be filed within 1 year after the date of the last payment. That sounds like a one-year limitation that's the statute imposes.
Correct, Your Honor. But again, that's for the initial 7A form. That
That's
opens
for-
the initial 7A form that gets filed with OWC, that opens up the claim, it opens up the record that the OWC is now responsible for managing. Additionally, when you,
Are you saying that the one-year filing of 1514A was satisfied here?
yes, it was, Your Honor, because she filed it within the year of her injury,
Within
The
the year of,
the injury. So it
you
was,
mean in 2011?
yes, Your Honor.
No, but then
So,
the statute says if payment compensation was made, and then it was terminated, if there was a last payment, it sounds like it says if she wants a resumption of payment, she has to file a claim for such a resumption within a year.
so there is a
Am I
difference.
misreading that?
There is a difference between this initial claim and a request for benefits. Requests for benefits don't have to be filed with the Office of Workers' Compensation or the Administrative Hearing Division. Those can go directly to the insurer or the employer, where the employee says, "My medical provider is recommending this treatment. I'm requesting authorization for this treatment."
But this says
Or-
such a claim shall be filed with the mayor.
Correct, and that's the initial 7A form.
No, when it says such a claim may be, they're talking about the claim made within the year after the last payment.
Correct, but in this case, it's already been filed within the year of the injury. It's one claim that gets filed for the injury and the associated benefits for that injury, and then after that is the request for benefits that either go directly to the employer and insurer, or then get adjudicated by filing the application for informal conference or the application for formal hearing.
You know, it really sounds to me like a remand to the CRB to explain this statute. Its interpretation of this statute might be a good thing to do. What do you think of that?
It seems clear both in practice and in the plain language and in the case law already cited, as well as the legislative intent, that this refers to how it's been done in practice since the enactment of this statute, that there is one claim filed, the 7A form, that
But
opens
the
the claim.
the CRB apparently did not read it that way in this case, right?
That's, apparently
Because-
they did not, correct.
Because they faulted her for not filing a claim within the year.
Correct, Your Honor. That was also because they were looking for some sort of limitation, and that's what they were able to find most applicable. At least it appears in their opinion.
Well, all right.
So-
Suggest an ulterior motive that I don't think we can really suggest, but
So with all that being said, I would just like to thank the court for your time, and we ask for reversal of the CRB's decision and finding that Ms. Crutchfield's claim is timely under the Act. Thank you.
Thank you. We'd like to thank both counsel for your briefs and arguments and your patience in addressing the court's questions today. Thank you.